All rise. Good morning, Your Honor.
Good morning, Your Honor.
Missing one juror? Two jurors. All right, well, we need to have a discussion about this evidence rule, so as soon as the defendant comes up, we can do that. We heard from the marshal? Good morning, Judge.
Good morning, Judge.
Well, look, if any of you have your computers with you, I have a case for you, 556 F3rd 151.
One more time?
556 F3rd 151. Here, you can all read it on my iPad if you have to write it.
Okay.
It's a recent Third Circuit case on present sense impression.
Yeah, it's not that. This is.
Your Honor, just a question. Wanted to make sure you got my letter on Friday.
Yes, I did.
Okay,
I have it
thank
right
you.
here, thank you. With the other additional cases. We'll discuss that as soon as the defendant comes. Okay, thank you. Well, this will take 5 or 10 minutes to have this discussion. Okay, thanks. Were you looking for me about anything else, or what? Do you want to go do it right now? I'll go in with you. All right. Okay. On my table, I presume? Yes. What? Oh. Great stuff.
Okay. Do you want to go see?
I'm sorry, what did you want?
I don't know. I just have to. No?
She was. 'Cause, you know, I don't know. 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 I don't
house arrest? No, I don't think so. I don't think I can.
Thank goodness for easy questions.
Yeah, that's what I thought.
All right, we're down to one juror missing.
Okay.
This is where the serial number should have been.
This number's on here. See if I can look
All of the jurors are here, so now all we need is a defendant. All right, well, look, let's have this discussion, and we'll rule in it until Mr. Seals comes in here. But I want to repeat what I mentioned last week, is that, in my view, the present sense impression under Rule 803-1 fits this better than the government's argument that it should be admitted not for the truth of the matter asserted, but to show the effect on the defendant. And so I found this case, United States versus get the right thing. Green, 556 F. 3rd 151. Now, in that case, Judge Sleet in Delaware had admitted the statement as a present sense impression. He was reversed on that because the statement was made 15 minutes after the event in place and after some questioning. But in this case, the statement is being made simultaneously with the police coming into visual conduct with Bryan Seals, the brother of the defendant. So I didn't ask Ms. Magid or Mr. Zork what your reason is for disputing, or you don't dispute it, or you think your argument is a better one?
Certainly, Your Honor. We are confident enough that we are correct in arguing that it comes in as not hearsay, that I'll actually argue against our original position regarding present sense impression, because we do feel that it would not be a reversible error, and it is the proper course to admit it as non-hearsay, and to admit it as non-hearsay because of its relevance. It comes in as non-hearsay because it is relevant to the state of mind of the defendant, and that's what's at question here. The defendant's state of mind, his consciousness of guilt, that is relevant evidence. If it comes in as a present sense impression, I believe that the relevance is a little bit less clear, because it's the present sense impression of his brother Bryan Seals, but Bryan's not on trial here. It's Ryan who is on trial, and Ryan Seals' state of mind, his consciousness of guilt as he looks at the approaching officers and throws the gun, that's what's relevant. And the fact that he heard a warning and had that reaction, that's what's relevant. It absolutely doesn't matter whether it was true or not. The truth of the matter does not matter. Some of the cases I cited to you included ones where someone heard something that turned out to be factually incorrect,
Right.
but they had a certain reaction to it, and that reaction was relevant to the case.
Well, I understand the difference between admitting something for the truth of the matter and admitting something just to show that it was said or for the effect on another person. But then you have to give the jury the instruction that it's not being admitted for the truth of the matter asserted, which in this context I think is hard to understand. And also, there's no Third Circuit case
approving this argument. The cases that you cited are all from other circuits. There's no precedential Third Circuit case in anybody cited here. Now, the clearest example of a present sense impression doesn't often arise in a criminal case, but rather in a civil case, such as in an automobile accident. You have a crash, and one of the bystanders, a third party, says, "Oh my God, the Buick went through a red light." And that's generally admissible as a present sense impression. Now here, Bryan Seals is a third party. He's not a defendant in this case. So it would seem to me that what he said is admissible, but that doesn't necessarily, then you still have to show that Ryan Seals, the defendant, heard that, or allow the jury to infer that Ryan Seals may have heard that. But you have to make that argument under your theory as well. So it is possible that I could admit it under both theories, but then the issue is what explanation I give the jury. All right, Mr. Adamo, what's your argument?
Well, Your Honor, I briefed the point. I think the key issue...
Wait, did you send me a brief? I didn't get it.
No, sir, no. I previously briefed this
Yes.
issue with present sense, and my argument really hasn't changed. There's no knowledge. You have Bryan Seals making a statement, assuming the court admits that. All right. Then there's a 403 issue.
Well, wait a minute. I don't, I can't, there's no legal theory on which I can preclude the police from testifying that they saw Bryan Seals and they heard him say something. The question is the content of his speech admissible? All right? I know he denies even being there.
Well, then the issue becomes, all right, whether or not, like I said in my brief, whether or not my client understood it, whether he heard it, all right, because
well, that's a fact issue.
But they're using this, they're making an inference, and it's a 403 issue, Your Honor. The prejudice here is that they're working in cahoots with one another. It's a reasonable inference that they're going to try to drive through, and there's no evidence that my client heard it. You're talking about a yell way up the block, something that happened spontaneously.
Well, that's up to the jury to prove. In my view, that's not a question under the rules of evidence. That's a question of proof, whether whatever Bryan Seals, well, first of all, I don't know if Bryan Seals is going to testify or not. It's not about, and I'm not asking whether he is or not. Okay, but the police are going to testify that, and the fact that he's the defendant's brother is relevant up to a certain point, but it's not relevant as to whether the defendant heard what he had to say. So that's a question of fact, of proof for the Commonwealth. They've got to prove that the defendant was in possession of his gun. All right? And as we know, they didn't find the gun on the body of the defendant. The testimony is that to allow the jury to infer that the defendant had it and that he threw it into the bushes. Is that right, Ms. Maggott?
Yes, Your Honor.
All right. So this is a case of constructive possession, all right? And they're going to depend on circumstantial evidence. Now, one of the circumstances is that Bryan Seals said something, all right? And I don't know why I can't admit this under both theories. That I think I can find that it's admissible as a present sense impression, and I think I could also find that it's admissible for possibly having an effect on the jury, having an effect on the defendant. But that depends on the jury finding that the defendant heard it and understood what it meant. And I would say it to the jury just like that.
I just respectfully...
No, I understand. You've preserved the record very well, and I understand you object to it.
Thank you, sir.
Now, Ms. Maggott, do you see some ideological impurity in this approach?
No, Your Honor. I agree that perhaps the safest and best course would be to admit it for both purposes And if you feel that an instruction is necessary, you could instruct the jury that it's not being offered for the truth of the matter asserted, the matter being the police are here. The government doesn't feel that instruction is necessary because the presence of the police is not a matter in dispute. But you could give that instruction and tell them that it is being admitted not for the truth of the matter asserted, the presence of the police, but for the effect on the state of mind of the listener, with the jury making the determination, as you correctly said, of course, whether he heard it in the first place.
Okay, all right. All right, you see, the reason why this is potentially, and I certainly recognize the distinction that is discussed in the cases that you cited. The reason why I think it is potentially confusing in this case is because there's no doubt that the police were there. Now, but it's not necessarily true that the defendant knew the police were there. That is, at least until, your argument would be at least until Bryan Seals called out one time.
Yes, Your Honor.
All right. All right, are the police officers the first witnesses?
Yes, they are.
Okay. All right, well, I'm going to admit the statement under both theories, and I will give the jury an instruction at the time that the testimony comes in. And if either counsel believe, and then I'll try and remember to ask either counsel if they want to come to sidebar to comment on my instruction. If so, I'll let you do that. But if you don't have to come just to repeat the objection you've already made, but only to clarify. Let me say one more thing about sidebars. I don't like sidebars, and I generally don't have them unless I see some necessity for it. I think we've raised all the legal issues ahead of time. Well, it's 9:15. We still don't have a defendant. You want to make another call, Janice? Thanks.
Your Honor, just a little bit of housekeeping then.
Yes.
We have the exhibits loaded on the computer and they'll come up, but I also have exhibit books. So if I can approach and give one to you and put one up on the witness stand, and I've already provided.
I have one.
Your down.
Thank you.
Your Honor, again, a matter of housekeeping. At the conclusion, when will we have a jury conference? Or
When
I don't
the
know.
evidence is done before arguments.
Okay.
Okay? Yeah, I don't think you've submitted points for charge. No, yeah, I mean, you don't have to, but
No, I would only request one regarding Reginald Gibson.
well, he's unavailable.
Right, yeah.
Right, okay.
Yeah.
Okay. And then can you put that on? Because it's long. This way or this? Okay. Yeah. This is the perils of being short.
Thank you.
Right, exactly. Yeah.
Thanks. We're going to have to add a charge there. Reginald is not available either, so. But the abstainer is not. But I'll go over that next. Let's wait and see. You may have to make some corrections. Okay, we're ready.
Yeah, you got the key. It'll fit the door.
All right, I give the jury about 7 or 8 minutes of general instructions first,
Okay.
and then we'll, but I'm going to let you talk to your client and just tell them what the ruling was.
All right, right. And you'll see, I'm quick.
Take your time.
Yeah. Yeah, that looks better.
We will only even consider the 1 through 45. Everything else is just a so you can just check off whichever one's after. Now hit the gun.
All right, Mr. Seals, good morning. We're ready to start the trial. I just want to advise you that while we were waiting for you, I had a brief discussion with counsel on the legal issue that was discussed last Thursday, specifically the admissibility of the testimony of the police officers that they encountered your brother, Bryan Seals, who testified at the pretrial hearing, and they heard him yell up the street, one time. After considering the legal issues that were presented by the briefs that were filed last week and some subsequent briefing over the weekend and another case that I located, I've decided that I will allow the police officers to testify concerning, testify consistent with what was said at the pretrial hearing. In the first place, there's a credibility dispute between the police officers and your brother, Bryan Seals, who denied that he was even present or made any statement. In my view, that does not present a legal issue. That's a fact issue of credibility of the police officers. The legal issue only arises with connection with the content of what the police officers would testify to as to what your brother actually said. And I've determined that that is admissible under Rule of Evidence 803-1 as a present sense impression, or it's admissible not for the truth of the matter asserted, but as a out-of-court statement offered only to show a reaction by someone who heard the statement, and the government argues that you were in hearing distance. Now that, once again, is not a legal issue. That's a question of proof for the government to make and a question of fact for the jury to find under my instructions. So I just wanted to let you know what the ruling was. Mr. Automotive, would you want a few minutes to discuss that with your client?
Just a couple of minutes, Your Honor.
Go ahead.
Okay, so do we have the gun? Do we have the gun, Laura? Do we have the gun, Laura?
No. Okay, are you done?
Yes, sir. Yes,
Okay, all right, bring the jury in, please.
Yes.
Okay.
Whatever you need.
Yeah, let's pass.
Yes.
Oh, a scissor? Yeah, it's scissor.
Does it look good? Oh, no.
Counsel on the scene.
All rise.
seated, please. Good morning, ladies and gentlemen of the jury. I'm sorry we're a few minutes starting late today. Nobody's fault in particular, just some details and issues that had come up, but we're now ready to begin. The first item for you is that I'm going to give you what are referred to sometimes as general instructions. These are things that have to do with the conduct of the trial and your duties and obligations as jurors, and they are the same. I give the same instructions in every case, and they're just for your general benefit and don't have anything to do with the facts of this case. The first thing I want to do is describe you how a trial proceeds. This little discussion I have will take another 6 or 7 minutes. Then we have opening speeches of counsel. And the prosecutors will go first because they have the burden of proof. And this is an opportunity for them to give you a roadmap or an outline of their case. And they will explain what they intend to prove. One reason we do this is that the counsel in the case can only call one witness at a time. So this gives them a chance to give you sort of a coming attractions or a preview of what their evidence is going to be. So they will outline to you what witnesses they're going to call and what witnesses and what testimony they're going to present in an effort to prove to you that the defendant is guilty beyond a reasonable doubt, which is what their burden is. And I want to emphasize to you that the opening address of either counsel is not evidence. The arguments of counsel are for you to consider, but they're not evidence. Now, when the prosecutor is done, then defense counsel has the option at that time to give an opening address, or he may wait until the government has finished its entire case. And the same rules apply to him. The defense counsel can explain to you what he will attempt to show you to show that there's a reasonable doubt as to why you should not convict the defendant of the crime charge. Then when we're done the opening addresses, which will probably be fairly short, then the government will start presenting its case. And the government presents its case by calling witnesses to the witness stand and introducing exhibits into evidence. All of the witnesses testify under oath, and their credibility is for you. And you're the finders of the facts. So the most important thing for the jury to do is to find the facts. And you do that by listening carefully to the testimony of the witnesses and determining their credibility. Credibility is a fancy word for believability. And it means, do you find that the witness's testimony is trustworthy so that you're willing to rely on it? And I'll have more to say about this at the end of the case. But just to give you an example that has nothing to do with a criminal case, suppose you had an automobile accident, a right-angle collision, and there was a traffic light there. And there were 3 witnesses on different corners, bystanders. And one of them said that the Buick went through the red light, and the other 2 said that the Ford went through the red light. Okay? So there was a conflict, and there was a trial about this, and they all came into court and testified. Now, none of them are lying. You'll all find that they're trying to tell the truth, but their testimony is different. And you'd have to decide to whom to give greater weight. That is, who was in a better position to observe? Who's the most reliable? Did one make any contradictory statements? Did one seem inconsistent? Is one more sure than the other? And things like that. That's what credibility is all about. If you find a witness is lying, well then that's certainly something that you want to take into account in determining credibility. But you may find that witnesses are credible, but some witnesses are more credible than others just because of the nature of their testimony, the value of their recollection, and things of that nature. So when we talk about credibility, we're talking in a broad sense the trustworthiness of the witness. So the government will call its witnesses one by one. And then when the government's done, then the defendant has the opportunity to present testimony if the defendant wants to. But in the criminal case, the defendant doesn't have to present anything because the defendant is presumed innocent. The burden of proof is always on the government. And when all the testimony is done, then the counsel will come back to you and they will present their closing arguments. And at that time, they will sum up the evidence and try to persuade you to cast your verdict in favor of their client. And then when that's done, then I will give you the charge of court and I will explain to you the legal principles that must guide your deliberations. Now, during the trial, it's most important to hear, if for any reason you haven't heard the testimony of a witness, raise your hand. and we'll stop the testimony and take a minute to repeat it or make sure that you've heard all the testimony. Because you're the jurors who are going to decide the case, you have to record the testimony. Similarly, if any of you have an emergency, need to go to the bathroom or something like that, raise your hand about that as well. Now, you've been given notebooks, and you're welcome to take notes. Some jurors take a lot of notes, some jurors don't take any notes. It's completely up to you whether you take notes or not. But the notes are for your personal use only. They are not evidence, they're not for trying to persuade other jurors of your point of view. They're to help you recollect evidence. Now, this is not going to be a long case, so if you're welcome to take notes and write down any names or dates or anything else you think is important, but this is not going to be, some cases stretch on for weeks, and therefore notes can be important in helping jurors remember what took place some time ago. You've been given juror badges to wear. It's important that you wear them when you go out into the hallways and use the elevators and the first floor. Because people who work in the courthouse know that if you're on a jury, you should not be approached or spoken to in any way. I doubt anyone would try to speak to you about this case. If that were to be the occasion, you should tell one of the court officers or myself. But you will also find that the lawyers won't say hello or goodbye or anything else to you, and that's because everybody who works here and tries cases here know that verbal and eye communication with jurors is just not a proper part of the etiquette. So don't feel that anybody's being rude to you by not being conversant. It's also very important that you not discuss the case with anyone, including discussing it among yourselves, until all the evidence and the arguments are over and you're deliberating. The reason for that is that some of you may arrive at a reaction to a particular witness early on, and you're entitled to that, but you should keep that to yourself, because you should wait until the cross-examination is done, until all the evidence is in and all the arguments are done, before you make any final decision. And if you were to give your immediate reaction to another juror, they might consider that as sort of an improper way to try and influence them or something like that, because they may not have had the same reaction. So when you're back in the jury room, or having a recess, or come back from lunch early or whatever, please remember, just keep the discussion away from this case. You can talk about the Eagles, you can talk about the Phillies, you can talk about shopping, or grandchildren, or children, whatever you like, but don't talk about the case until you're ready to deliver. Now, when witnesses are called, there's four different types of testimony. The party who calls the witness starts out the question of what we call direct examination, where the questions relate to what the witness knows of his or her own personal knowledge. Then the opposing counsel gets to cross-examine the witness, and they want to challenge the witness on the witness's recollection or credibility or anything else that's relevant. Then the party that called the witness has a chance to ask redirect questions to bring up or try to clarify anything that came on the cross-examination. And lastly, the opposing counsel then gets a final chance at what we call re-cross-examination, which is usually confined to what happened on the direct examination. Now, counsel are under obligation to object to testimony when they feel it is improper under the rules of evidence. And it's my job to rule on the objection. The objections are not addressed to you, they're addressed to me as the judge. And you should not consider the objections in any way in determining the facts of the case. If I overrule the objection, that means I find that the question was proper and the witness can testify as to the question. If I sustain the objection, that means I find that the question is improper, and if the witness has already answered the question, I may tell you to strike it, which means you should ignore it. Do not hold it against one party or the other because their attorney objects or makes objections. That's a lawyer's job to object during the trial. So you should not pay any attention to it or let it influence your verdict. The only other thing I want to say is that you're welcome, I think I said, you're welcome to bring a drink in or keep it at your desk. We take a mid-morning recess, and then lunch will be maybe a little longer than an hour today because we have a judges meeting, and then we have mid-afternoon recess, and we do not sit any later than 4:30. Okay, that completes the preliminary instructions, so we're now ready for the prosecution to go through.
Thank you, Your Honor. Mr. Damo, ladies and gentlemen, of the jury, good morning. On August the 10th of 2011, at about 11:45 midnight, Officers John Terry and Robert McEwen were working as members of the Philadelphia Police Department. They were in a marked police car and they were in full uniform. And they were driving in the area of 17th and Butler Streets here in Philadelphia. They first observed a man walking northbound on 17th Street, and he looked in their direction and then yelled out, "Yo, yo, one time, one time." The officers will tell you that that language in urban slang means police, police. Within seconds of hearing that cry, they heard 5 to 8 gunshots down 17th Street. Officer Terry will tell you that he saw a person on a porch about 3/4 of the way down the block, and he saw that person run into the house. He saw only one other person down the block on the west side, and that person turned out to be the defendant in this case, Bryan Seals. He saw Mr. Seals on the sidewalk about 1 to 2 houses away from the person that he had seen run into the house from the porch. Both officers will tell you that they saw Mr. Seals, who originally was turned away from the officers, turn towards them, sort of fall slightly to the ground, then turn around completely and start walking towards them. And almost immediately they saw him make a motion with his right arm, throwing an object into the bushes on the street. They will tell you later on that that object is consistent with a handgun in size and shape. Mr. Seals then continued down the street towards the officers, put his hands up in the air and said, "They're shooting." And he eventually was stopped by Officer Terry. Officer McEwen went over to the bush where they had seen Mr. Seals again make that motion and throw an object into the bushes. And after a thorough search of the bush, he found one object, this handgun, which is a .380 semi-automatic handgun that had one bullet in the magazine and had one bullet in the chamber. The police will also tell you that they found in the same area where they had first seen Mr. Seals 2 what they call fired cartridge cases, these 2 little guys here, which basically are what is ejected from the gun after a gun is fired. And they found those 2 on the sidewalk right near the bush where Officer McEwen found the gun. You're going to hear testimony from a firearms expert that he did an analysis, first of all, of the gun and these fired cartridge cases. And he will tell you that based on his analysis, the fired cartridge cases, these 2 little cases, came from this same gun that Officer McEwen found in the bushes. He will also tell you that he tested the gun itself and that it's operable, it's capable of firing a projectile. Now, the charges in this case, or the charge in this case, is that Mr. Seals is charged with being a felon in possession of a firearm and ammunition. His Honor will tell you somewhere down the line that there are basically 3 elements that make up that charge. Number 1, that the defendant knowingly possessed, had in his possession, the firearm and the ammunition. Secondly, that the possession of that firearm was in or affecting interstate or foreign commerce. Now, the government can prove that element by simply showing that this gun was made in a foreign country or came in to Pennsylvania from another state. You're going to find, you'll hear testimony that this gun was actually manufactured in Spain, and you can see on the gun itself that it brought in through Alexandria, Virginia. Furthermore, there's a stipulation or an agreement between the defense and the government in this case that the firearm and the ammunition did impact interstate commerce. So to that extent, that decision is already made for you if you choose to accept it. The third element that the government has to prove is that the defendant previously was convicted of a crime punishable by imprisonment for a term exceeding 1 year. And again, there is a stipulation or an agreement between the defendant and the defense and the government in this case that is so, that he has that prior conviction for a term exceeding 1 year of potential imprisonment. So in effect, ladies and gentlemen, what the issue before you is whether Bryan Seals possessed this gun on August the 10th of 2011. And that's a decision for you to make. And as His Honor has already indicated earlier, how you go about doing that is by watching the witnesses when they testify from that witness stand, determining their credibility, and in effect determining what the truth is in this case. At the conclusion of this case, based upon the truths that you find coming from that witness stand, from the witnesses, Ms. Maggot is going to stand up in front of you and ask you to convict Bryan Seals of being a felon in possession of a handgun, a firearm, and ammunition in this case. Thank you.
Okay, Mr. Adamo, you want to address the jury at this time?
Yes, sir. Government counsel, Your Honor, ladies and gentlemen of the jury. This case comes down to observation, a correct observation or an incorrect observation that determines whether or not we find my client guilty or not guilty. I ask that you listen to the direct examination as the government will lay out its case with exhibits. I also ask that you listen to the cross-examination. At the conclusion of this case, Your Honor, Judge Baleson will charge you. And one of the most important charges deals with the whole concept of reasonable doubt. And that hinges pretty much on whether you feel that the government has proved this case beyond a reasonable doubt as to whether my client actually possessed this weapon. You'll get an idea of the area. You'll get a very good idea of the area through the exhibits. You'll get an idea of the lighting conditions. You'll get an idea, you'll get a feel of what the officers went through when they made their observations. And then it'll be up to you, relying on your common sense and your common impressions to determine this particular case, the innocence or guilt of Mr. Seals. And I ask you to consider the direct examination, but I also ask you to consider the cross-examination. I also ask you to listen very carefully to Judge Baleson's charge at the conclusion of the case dealing with reasonable doubt, because it's the defense position that the government will not be able to prove beyond a reasonable doubt that my client possessed a weapon. And at the end of the case, I'll have an opportunity to address you. Thank you very much.
Okay, ladies and gentlemen, we're now ready for the first witness.
Officer Terry, Your Honor.
Police Officer John Terry, Terry.
Thank you. Please speak into the microphone.
proceed, Your Honor? Officer Terry, good morning.
Good morning.
Let me call your attention to the date of August the 10th, 2011, at about 15 minutes until midnight. Were you working as a Philadelphia police officer at that time?
Yes, sir.
And were you, how were you working? With marked car, unmarked car, plainclothes, whatever?
Marked car in full uniform.
Were you working by yourself or with a partner?
I had a partner.
Okay. And who was your partner at that time?
McEwen?
Okay, Robert McEwen?
Yes.
Were you in the area of 17th and Butler Streets at about that time?
Yes, sir.
Tell the ladies and gentlemen of the jury what you saw as you were in that area.
We were traveling northbound on 17th Street. 17th Street is two ways. It's one lane in each direction with parking on one side of the street. As we were traveling northbound, I observed a male walking on the east sidewalk. He looked over in our direction and he started to yell, one time, and he cupped his hands up over his mouth and he yelled again, yo, yo, one time.
All right, just let me interrupt you, officer, for a minute. All right, ladies and gentlemen,
I don't do this frequently, but I just want to give you a preliminary instruction about this testimony. You've heard this witness testify about what another person said, this other individual who you described. Now, as a general rule in law, that we only allow witnesses to testify as to what they did or what they said themselves or what they observed with their eyes or ears or senses. We don't generally allow witnesses to testify as to what other people said. However, as with just about every other rule, there are exceptions to that rule. And one exception to that rule is where somebody makes a present sense impression. Now let me go back and give you an example of what I mean by that. We're going to talk about a civil case, and we're going to talk about right angle collision like I talked about before. So let's say we have this two cars and they go through a red light. One of them goes through a red light. There's a dispute about who went through the red light, who was bystanders. And there's a trial that takes place where the two drivers are suing each other, and one of these bystanders testifies. And there's testimony about the bystander, not from the bystander himself or herself. And one of the witnesses wants to bring out something that the bystander said just minutes or seconds after the accident happened, such as the Buick went through the red light. Okay? That is what the law would consider a present sense impression that is defined as follows. It's a statement describing or explaining an event or condition made while the declarant, that is the person who made the statement, was perceiving the event or condition or immediately thereafter. So in that situation, what the bystander said would be admissible as a present sense impression, even if the bystander himself or herself was not the witness. Okay? Maybe they're not a witness because they moved away, or maybe the guy, they're not available, but somebody else could testify as to what they heard the bystander say seconds after the crash. Similarly here, this witness, the police officer, is being allowed to testify as to what this third party said, what he heard him say right at that minute, okay? Because according to the officer's testimony, he's observing the police officer, and he's calling out in street language the fact that police officers are there. So that's a present sense impression. Now, another reason why this testimony may be considered by you, but not for the truth of the matter, is I'm going to hold off instructing you on that right now. We'll wait for some more testimony. Go ahead.
When you heard this man yell out, yo, yo, one time, were you the driver of the car or the passenger of the car?
I was passenger.
So he was closer to you than to your partner?
Yes, he was on my side.
And did you subsequently find out the identity of that person who yelled out, yo, yo, one time?
Yes.
And what was his name?
Bryan Seals.
When you heard this, what was the next thing that happened?
I heard gunshots
Okay, within how short a period of time?
almost immediately.
Could you tell how many gunshots you heard at that point?
About 4 to 6, 4 to 7.
Okay. And what did you see or do at that point?
Well, as soon as I heard the gunshots, I looked up the direction where they were coming from. They were coming from in front of us.
Okay. Could you tell whether the left side of the street or right side of the street at that point?
It would have been my left, the west side of the street.
Okay. And what, if anything, did you see when you looked up the street?
I observed someone run into a house,
Okay.
and I observed the defendant. He turned towards us, stumbled, threw something with his right hand off to his side. He then put his hands up, and he came running towards us.
Okay. Let me take you back. So
Okay, now, just a minute, let me interrupt.
Now you've heard the officer testify concerning his observation concerning the defendant, Bryan Seals. And remember, there are two people for the last name Seals. Bryan Seals, B-R-Y-N, and the officer testified he later heard his identity. He's the one who made the statement. According to the officer's testimony, the defendant's name is Ryan Seals, R-Y-A-N. So you have to be careful in one of either of those is mentioned that we understand who the witness is talking about. Now, in this situation, the officer described certain conduct by the defendant. Now, that's for you to determine exactly what happened. But my instruction to you is that you may consider the statement made by Bryan Seals, B-R-Y-A, the brother, that the officers heard if you find the statement was made, as the officer testified. You may consider that, not for the truth of the matter, sir, but that a statement was made that was heard, may have been heard, that's for you to determine, by the defendant. And that may have had some effect on him, and may have caused him to do what the officer saw him do. Now, this is a question of evidence and of fact for you to determine based on all testimony and the arguments of counsel and the instructions that I'll give you at the end of the case.
Okay, thank
Does
you.
either counsel want to see me at sidebar about that?
No, sir.
No, thank you.
All right, proceed.
Let me take you back, officer. You said when you first looked up, you saw someone running into a house. Is that correct?
Yes.
Where was that person when you first saw him?
He was up on the porch between the door and the house.
Okay. And then you said you saw a second person who you identified as a defendant, all right?
Yes.
Who are you referring to in this courtroom as a defendant, by the way? How was he dressed?
Bryan Seals.
Okay, how was he dressed?
White shirt, suit jacket, black suit jacket.
Okay.
Stipulate.
Okay. Indicate for the record the defendant, in this case Ryan Seals. Where did you first see Mr. Ryan Seals when you looked up?
He was on the west side of the street.
Okay. Where in relationship to the person that you saw run into the porch, from the porch into the house?
He was on the sidewalk.
Okay, but 10 houses down, a couple houses down?
About 2 houses.
Okay. And was his back to you first or his face to you when you first saw him? If you remember?
His back was to us first.
Did you see anyone else on that west side of the street other than the person who ran from the porch into the house and the defendant in this case?
No.
When you heard the gunshots, was your car still moving up the street or had it stopped at that point?
We were still moving.
Okay. Did you eventually stop?
Yes.
What did you do at that point? Well, let me, before you do that, you said you saw Mr. Seals turn and he threw something, is that right?
Yes.
Could you tell exactly what that object was at that point in time?
No.
What kind of motion do you make when he threw the object?
A sideways
Show us
throwing
with your-
motion
show us
with
with
his
your
right
arm.
hand.
Show us with your arm what you saw.
Stand up and show the jury.
It was a sideways motion,
Okay. Indicating
just from the side.
to the right, Your Honor, from the body out to the side. And then you said you saw Mr. Seals coming down the street, and what did he do at that point?
He put his hands up.
Did you then, at some later point, see your partner Officer McEwen look into the area where you had seen Mr. Seals throw the object?
Yes.
And where did the object land, if you know? Could you see where it went?
Off to the right side, with the lawns, when there's a bush there.
Okay, so into the bush?
Yes.
Did you see your partner go into that very same bush and conduct a search in that area?
Yes.
And did you see him retrieve anything from that area?
Yes.
What was it that you retrieved?
It's a handgun.
Now, you didn't deal with that handgun at that point. You didn't put it on a proper receipt or anything else along those lines. Is that correct?
No.
Your partner did that?
I believe so, yes.
But did you see the object at some point later on?
I did say it.
Was it in size and shape, weight, as far as you could tell, consistent with what you may have seen Mr. Seals throw into those bushes?
Yes.
Did you or your fellow officers also discover fired cartridge cases in that area?
Yes.
Tell the jury what a fired cartridge case is.
We have a semi-automatic handgun. The bullet, before it's fired, the projectile is part of the casing. After you fire the gun and the bullet projectile is fired, the spent casing comes out of the gun.
Let me show you what's marked as Government Exhibit 7 for identification purposes. Is this similar to what you're talking about?
Yes.
That part remains where, or goes where?
Out of the gun.
Out of the, all right, and where were these fired cartridge cases found in relationship to where Mr. Seals had been standing when you first saw him?
Right in the immediate area.
Did you also at some point in time go up on the porch where you had seen the person run into the house, the person you had first seen on the porch, you ran into the house?
Yes.
And did you find any type of markings anywhere on that porch?
Yes.
What did you find?
There was a strike mark from a bullet on the front door of the house. And there was also 2 shell casings on the porch next to the house.
Okay. Now, when shell casings come out of a gun, do they normally drop straight down in your experience?
No.
Do they shoot out to a certain distance either way, left or right?
Yes.
Let me show you what's marked as Government Exhibit 1 for identification purposes. Can you see that from where you are also?
Yes.
How long have you worked, which district do you work in?
39.
And how long have you worked in the 39th Police District?
About 13 years.
You are, therefore, I assume, familiar with the area of 17th and Butler, is that correct?
Yes.
And familiar with the area of North 17th Street where all this happened, is that correct?
Yes.
Based on your, and I'm assuming you've been on that street many times, is that fair to say?
Yeah, that's correct.
Based on your observations, in Government 1 purports to be a map of that area. Does that look consistent with what you know as 17th Street and have those intersections to look like?
Yes.
I'm going to ask you to look in the binder that's in front of you at exhibits number 25 through 32. The binder right in front of you. And if you just leaf through those 25 through 32 to yourself, first of all. Have you had a chance to look at those?
Yes.
Are you familiar what's depicted on Government Exhibits 25 through 32?
Yes.
And what in general do they show?
That's the area where this incident took place.
I want to draw your attention, first of all, to exhibit number 25. And that should also appear on the screen right in front of you as well. You see it there?
Yes.
And that's not appearing on the jury screen yet, is that correct? Okay. Tell us, first of all, what Government Exhibit 25 depicts.
That is the 3800 block of 17th Street.
Okay. And where is Butler Street, Butler and 17th? Is that depicted on that photograph as well?
Yes.
Your Honor, we move for the admission of Government Exhibit number 25 and ask that be published to the jury.
Any objection?
No, John.
Admitted.
Can you show, Officer, where it was, if it's shown on this photograph, where you first saw Bryan Seals?
Or can the jury see the photo? At any time, if I admit something you don't see it, raise your hand. This is, just let me comment, this is an electronic courtroom, so we have basically all the exhibits it's shown on your screen there rather than passing paper around. It saves a great deal of time. You'll have the actual exhibits in paper when you deliver. Go ahead, proceed.
Okay, if you can, is it shown on this, on exhibit number 25, where you first saw Bryan Seals when you were coming down 17th and Butler Streets?
Yes.
Where you can actually point to it on the screen, it should make a mark.
It's right around this area here.
Okay.
I-
So you were part ways down 17th Street when you first heard Mr. Seals, is that correct?
Yes.
Okay. Let me approach you, Mr. Judge, and release that in the camera. And if you just... Can we see Exhibit 31, please?
It's all good.
Yes. Can you tell, ladies and gentlemen of the jury, well, first of all, what do you see on Exhibit 31, sir?
The bush.
Okay, when you say the bush, what bush?
This is the bushes where my partner.
Lost the picture?
They're not supposed to have a picture, Judge. We haven't moved this into admission yet.
The procedure is that they show it to the witness first, and get it, if it's admitted, then
You say the bush, what bush are you referring to?
That's the bush where my partner recovered the firearm.
Okay. Move to have that admitted to evidence and published to the jury.
No objection. No objection.
Can we see Exhibit number 28, please? Can you tell us what's in Exhibit 28, sir?
Yes. The house that I saw the one male run into. The tree where I first observed Mr. Seals, and the bush where the firearm was recovered.
Move for admission, Your Honor, of Exhibit 28, and that be published to the jury. Okay, can you show us, Officer, you said that first of all, you saw the porch where the person ran into.
Yes.
Can you point to where that is on the screen itself? And touch the screen? Okay. Where was it that you first saw the defendant in this case when you saw that person running into the porch or into the house, rather?
Right here.
And you would refer to a tree, is that correct? That tree you're talking right to the immediate right?
So the second mark is
Where I first.
on the sidewalk between the bush and the...
Right.
Yes.
And is that where you then saw Mr. Seals turn and start walking in your direction?
Yes.
And that bush that's immediately to the left, is that the bush that we saw earlier on Government Exhibit number 31?
Yes.
We see Exhibit number 29, please. Can you tell us what's depicted in exhibit number 29 also?
The tree.
Actually, let me, can you erase those spots you saw there? Great, all right. So this is the same area we saw just from a different angle, is that correct?
That's correct.
Move to admit, Your Honor, exhibit number 29 and publish it to the jury.
All right, admit it.
Can you show us, sir, generally from this angle where it was that you saw? And this would have been the view you had as you were coming up the street, is that correct?
Yes.
Can you show us where you first saw Mr. Seals, the defendant in this case, when you heard the gunshots, saw the person run into the porch, and then observed Mr. Seals?
Mr. Seals was approximately right here,
Okay.
in this area.
And where was it that the fired cartridge cases were found after Mr. Seals had been taken into custody?
That exact area.
Can we see exhibit number 26, please? All right, can you tell us what is depicted in exhibit 26, please?
It's just a bigger view of the area.
Okay. Where was it that you actually wound up stopping Mr. Seals as he came down the street?
Right in this area here.
Okay, move to admit exhibit 26, have it published to the jury, Your Honor. 26?
Yes.
Okay.
Admit it.
All right, now you've already put an X, officer, next to a pole there, is that correct? That's generally where you stopped Mr. Seals, is that correct?
That's correct.
We see exhibit number 30, please. If you could erase that X first of all. What is this? Just a different angle again of the same area?
Yes, different angle.
Move to admit, Your Honor, this exhibit 30 and publish to the jury.
Admit it.
Okay, so where again are you arresting Mr. Seals? Okay. Let's see exhibit 32, please. Can you tell us what is shown in exhibit 32 also?
That is the bullet strike mark on the door.
That's on the porch of where you said you'd seen someone run in, is that
Yes.
correct? Move to admit exhibit 32, Your Honor, have it published to the jury.
Yes.
Can you show the jury, officer, what you're talking about? Maybe it's obvious where the bullet strike mark is.
There.
You are familiar with that street, is that correct?
That's correct.
What type of houses, or I guess it's obvious from the photographs, what types of houses are on that block on the left-hand side and the west side?
There are row houses.
Alleyways in between the houses?
No, there's an alleyway at the corner of Butler,
Okay.
and then there's an alleyway off of Pike Street.
And using Government Exhibit 1, can you, why don't you get down and show the jury, if you can, if it's shown on Government Exhibit 1, where the alleyways would be in this case.
There's an alleyway that runs this way, and then comes up this way, and there's an alleyway that comes straight down this way.
Your Honor,
Yeah,
Yeah.
indicating for the record,
I had to see it, Your Honor.
Will you come up and see it?
Yeah.
Well, come around, put the fold around so the defendant can see it also.
The alleyway runs this way,
running east to west.
east and west, and then there's an alleyway that runs north to south down this way.
Okay. Could that be depicted in this little,
Yes.
okay. But in the area where this all took place, there are no immediate alleyways, is that correct?
No.
To get to the alleyway, you have to pass you.
Listen, I want to, in this way that the defendant can see it and the jury can see it. I want to have it go back further there.
Yes. To show us where the alleyways are, as far as you know.
The alleyway runs north and south down in between the houses, and then there's an alleyway that runs east and west.
And in the immediate area where this took place in the middle of the block, there's no immediate way of getting out until you get down those alleyways, is that correct?
Correct.
Unless you ran into a house.
Yes.
Take a stand again for a second. On that evening when you heard the shots and you looked down the street for the first time, did your radio patrol car have its lights on?
Headlights.
Okay. So those lights were flashing down, or were directed down the street, is that correct?
Yes.
In that area, are there street lights at all?
Yes.
How about the houses themselves at night? Did any of the houses have on, or did they have, first of all, regular lights on the porches, and were any of them on that night?
Yes.
Just have one moment here. No further questions?
Cross-examine.
Good morning, Officer Terry.
More.
On August 11th, 2011, you were working the 6-2 shift with your partner,
That's correct.
and is that your regular shift?
Yes.
And that's out of, what, the 39th precinct?
That's correct.
And you testified, I believe it was exhibits 25 through 32, which showed the Butler Street and 17th Street, correct?
That's correct.
And now, the time of this incident was 11:45 PM, correct?
Approximately, yes.
And it was dark outside.
Correct.
It was a summer night.
Yes.
And you indicated that there's cars parked on just one side of the road, correct?
Correct.
And that was the side of the road where the incident occurred, correct?
Correct.
And it is a residential area, correct?
Correct.
And normally at that time of night, there would be cars parked up and down or just packed that area on the side where the incident happened, correct?
Correct.
And it's a two-way.
Yes.
Now, you indicated that, I believe it was in one of the exhibits, bear with me for a second. May have been exhibit 25, where you indicated where you heard Bryan Seals yell something, one time.
That's correct.
And that was around, that was at the beginning of Butler and 17th, correct?
Correct.
And this incident happened substantially up the street, correct?
Correct.
You have no way of knowing as to whether or not my client heard that particular warning, correct?
No, I would not.
Now, the person who you saw running into the house, do you know the name of that individual?
No.
You don't know if it's Reginald Gibson? That name doesn't, that rings a bell?
Rings a bell, yes.
Okay. Now, when Mr. Seals came running towards you, do you recall him telling you that they're shooting at him?
Yes.
Okay. And he had his hands up?
Yes.
Okay. Initially, he was down on the ground, then he got up, correct?
Yeah, he stumbled and then
He stumbled.
Yes.
Right. And he ran towards you.
Yes.
Did you have your overheads on?
No.
You just had your lights on?
Yes.
And well, you don't know whether or not he'd be able to identify whether that was a police vehicle. You have no way of knowing that.
I would not know.
But he saw your vehicle coming up, and he looked to you as, he said, they're shooting at me, indicating that he wanted help from the officers.
I don't.
Objection.
I don't believe they said they were shooting at him. He said they're shooting.
Okay. But he came to you. He ran towards you.
Yes.
Who's he?
Mr. Seals.
This defendant?
The defendant, yes, sir. Defendant. Now, the photographs through Exhibit 25 through 32, they're daylight photographs, correct?
Yes.
And in the evening, it looks quite different. It's substantially darker.
Yes.
All right. And I think you indicated, if I'm correct, that you were the passenger?
Correct.
All right. So if you were the passenger, based on, I would assume, Government Exhibit 25, you'd be coming down the street? You could look at that? Or were you coming up the street?
From,
Exhibit 25,
May we publish that to the jury, Your Honor?
Right,
yes.
May we publish 25 to the jury?
Yes, please, yes.
25.
I'm sorry. Thank you very much.
I would have been coming up the street,
Okay, so,
Can you say up, meaning north or south?
north.
okay.
North?
Yes.
So from the bottom of the photograph, you'd be going
To
up
the top of the
from
photograph.
the
yes.
top of the photograph?
I was traveling, can I still?
Please, yeah, please mark it. All right, no way. I see, okay, thank you very much. All right. So you're traveling up. So the incident occurred, as you were traveling up, the incident occurred on the other side of the street.
Yes.
All right. And shortly after you apprehended Mr. Seals, was there Mr. Richard Robinson and Samuel Black apprehended or stopped for questioning?
There was two other males stopped. I don't remember their names.
Okay. No further questions, Your Honor.
All right, redirect.
Those two other males, when was the first time you saw them, or where were they?
They were coming off of Pike Street on to
Would you indicate
17th.
on Exhibit 25 where Pike Street is?
Pike Street's all the way, I can't even see Pike Street
Okay.
in this picture.
So all the way further north on the street, is that correct?
Yeah, it's got to be all the way up this area somewhere.
Were they anywhere near the west side where you heard the shots coming from, where you saw the person running into the house?
No, they came east.
And the only person, again, I believe he testified on the west side was the defendant in this case, is that right?
Yes.
Mr. Adamo asked you about Bryan Seals yelling one time, and whether you knew whether the defendant had heard him.
Know what that is? Switch man.
Did he yell as loud as that sound that we just had before? Did he say one time, or did he yell it?
He yelled.
And, I mean, you've had experience of people yelling. Do you think people down the street could have heard him? Did he yell loud enough?
Can the jury hear what you just did?
I'm yelling out, Judge.
I've never heard that noise before. All right, let the record show, we just had a series of loud noises in the courtroom from some outside source. All right, go ahead.
You've had experience of people yelling, right?
Yes.
I mean, was it loud enough, in your opinion, that a person down the street could hear it?
Yes.
No further questions.
Recross.
No further questions, Your Honor.
All right. Thank you, Officer Hughes. Next.
Thank you.
Thank you. The government will call Police Officer Robert McEwen.
Please raise your right hand. You do swear and or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God, and or you do so affirm.
I do.
Please state and spell your last name for the record, please.
Officer Robert McEwen, MCCUEN,
Thank you, sir. Please speak into the mic, please. Thank you.
Good morning, Officer McEwen.
Good morning.
At approximately 11:45, just before midnight, on August 10th of 2011, were you on duty?
That's correct.
Okay. And do you see anybody in this courtroom that you saw on that date at that time?
The defendant seated next to us.
Okay, can you indicate what he's wearing?
Black suit, white shirt.
Indicating the defendant.
Thank you. Officer McEwen, how long have you been a Philadelphia police officer?
10 years.
Okay. And in the summer of 2011, what was your assignment?
Patrol.
Okay. And on the evening of August 10th, 2011, where were you working?
In the 39th District,
Okay. Were you working alone or with a partner
I had a
then?
partner.
And who was that?
Officer Terry?
Okay. Were you in uniform that evening?
That's correct. Full
And-
uniform.
Okay. And were you in a marked police car?
Yes.
And who was driving?
I was the driver.
You were the driver.
That's correct.
Again, at about that time, 11:45 on the evening of August 10th, did your tour of duty take you to the intersection of 17th and Butler?
That's correct.
Okay. And what part of the city is that in?
Like the Nicetown Tioga section, I guess would be.
Okay. When you were near that intersection, did you see or hear something that caught your attention?
I did.
And what was that?
I observed a black male. We were traveling northbound on 17th Street. We just passed, we came up to a stop sign at Butler Street. As we were at the stop sign, we were proceeding, we observed a black male running, I guess it would be westbound on Butler. And as he turned to go...
Just a minute, just a minute. I don't know what this noise is. All right, hopefully it stopped. Go ahead.
We'll keep our voices up.
Yes.
As we were traveling northbound, just as we crossed over Butler Street, we observed a black male that was coming westbound on Butler. He turned northbound on 17th and yelled, "Yo, one time, up the block."
You said you saw the man. Did the man see you?
I believe he looked at us.
Okay. And what does that phrase, one time, mean in your experience?
It means that police are on the block.
Okay. Later that evening, did you learn the identity of the man that said one time?
That's correct.
And who was that?
It was Bryan Seals.
And is he related to the defendant?
Objection, Your Honor.
Well sustained.
Okay. In what direction was Bryan Seals yelling this one time?
He was yelling northbound up the block
Okay. And how many times did he say this?
twice.
Okay. And how loud was he speaking?
Loud enough, I mean, he cupped his mouth when he
Can
yelled
you
up the
show
block.
us how he did that?
Like that.
Indicating putting his hands up to his mouth and calling out?
Correct.
Okay. Was he yelling loud enough for someone going up the block, north on the block, to hear him?
Objection,
Yes.
Judge, speculation.
Sustained. All right, that, ladies and gentlemen, that'll be stricken. All right, that's leading and to conclusion, so rephrase the question. You can ask him to describe the yelling.
Certainly, Your Honor.
Describe how the words were said.
Yes, can you describe for us or indicate how loud he was yelling?
Yo, one time! Like that.
All right, so the witness says, did you see him put his hands to his mouth and you just did?
Yes, because our attention was still drawn to him at that point.
All right, and he raised his voice a considerable level above the normal speaking volume. All right, go ahead.
Okay. You have an exhibit book in front of you. If you could turn to Government Exhibit 25 in that binder. Do you recognize what's depicted in that photograph?
That's correct.
And what is that?
That's looking northbound on 17th Street from Butler.
Okay. I'd ask that Exhibit 25 be shown to the jury. That's been admitted.
Yes, I think they already saw it. It's been.
Yes.
Okay.
I showed it again.
Okay. On the screen, if you just touch the screen, a red dot or arrow will come up. And if you can indicate first where you were when you first heard Bryan Seals. Okay. And can you also indicate where he was?
Your Honor, it's not showing up on my screen.
It's not coming up.
Okay, all right, now I see it. Now I see it, it's two little dots.
Yeah,
Yeah.
you know what, can you just make an X for
Did
us?
Jerry see it? Right.
Thank you.
Okay, and the X is, so just barely turned the corner onto 17th from Butler, is that one on the right? Is which one?
The one in the middle of the street would be our vehicle. The one on the sidewalk would be Bryan Seals.
Thank you. And if you could just touch the lower right. Left, I'll get this correct. Those X's should disappear.
Lower left.
Try the lower left. All the way over to the left.
Just show Laurie.
Now,
Just push it.
Oh, the exit button.
Yeah, it goes.
The exit button.
Officer, after you heard that warning, what happened next that caught your attention?
We heard several gunshots go off.
Okay. Approximately how many gunshots did you hear?
5 to 8.
And how long after you heard Bryan Seals make that warning did you hear the gunshots?
Approximately 1 to 2 seconds.
Okay. Where did it sound like the gunshots were coming from?
About middle of the block, northbound.
Okay. On the east side or the west side?
On the, I guess it would be the,
Why don't I step,
it'd be the side where the vehicles are.
okay. You know what, if you could step down and just show the jury on, we have a map here. And I'm going to try to get it someplace where everybody can see it. Watch the board there. Can you show the jury, in fact, as long as we're here, can you show us where you were when you first heard the warning? And then can you show us on this map approximately where the gunshots came from? Which side of the street?
They came from this side, about mid-block, somewhere up in here.
Okay. Thank you, officer. If I come back to this in a minute. Okay. So when you heard the gunshots, do you know where Bryan Seals was, whether he was behind you or in front of you or alongside you?
We were just going past him.
Okay, thank you. After you heard the gunshots, did you see anyone else on that block besides Bryan Seals?
No, not until I drove a little farther.
Okay. After you drove a little farther, who did you see?
I seen the defendant.
Okay. Can you tell us where you saw him?
He was about up the block. There's a tree and a pole. He was between them two, on the left-hand side.
Okay. And what was he doing? What did you see him do?
When he turned around, he seen us. That drew my attention towards him. He made a movement with his right hand, like this.
Indicating throwing out from the right side of your body?
That's correct. And I saw an object. I couldn't tell what the object was at that time. As he threw it, he kept his hands up and he's saying, "They're shooting at me, they're shooting at me." And he kept walking, like almost past our car. My partner went around the back. I went towards that area over there where I seen him make the motion, the hand motion,
Yes.
the throwing motion.
Okay. How soon after the gunshots, after you heard the gunshots, did you see the defendant?
Oh. It was almost instantly, like, because we were still driving up the block. We never stopped when he yelled one time, so
Okay.
we continued up the block.
When you heard the shots and you saw the defendant, was there anyone else on the sidewalk near the defendant?
I observed nobody.
Okay. When you were approaching the defendant, did you have your car headlights on?
The headlights were on.
Okay, so the headlights were facing in which direction?
They were
Towards the
facing
defendant?
northbound towards the defendant.
Okay. Besides your headlights, were there any street lights on that block?
Yes, there was traffic lights on, and there was also a couple porch lights. Like you can see in the picture up on the people's patios, like towards their house, there's a couple lights on.
So there were both the street lights and personal porch lights on
That's
people's
correct.
houses? Okay. And what was the weather like that day?
It was clear. It was dark out, but there's enough lighting on the block.
Okay. You said the defendant saw you?
That's correct.
Okay. When he threw the object, object that you said he threw away from his body, were you able to see exactly what the object was?
Not at that time. I could see that it had some size to it, but I couldn't tell you what the object was.
Okay. When you say some size, can you describe?
It, you know,
the size?
hand size of your hand,
Okay.
but I mean, it wasn't something real little.
Could you tell anything about the weight of it?
No, not at that time. I mean, it went with some force, but
It went with some force. Okay. Did you think that the size and the weight were consistent with a handgun?
it could have been, yes. But like I said, couldn't tell what it was at that time.
Okay. So after the defendant threw the object in the bush, what did he do then?
He walked past us, still with his hands up, saying they're shooting.
So what did you and your partner do at that point?
My partner stopped Ryan Seals. I went over to that area. As I was over at that area, I was searching for whatever the object was.
Okay.
That's when I came across the shell casings. They were laying on the ground. There was a couple shell casings right about where he started turning around the wall when we seen him at first. At that point, there was two other males from the other end of the block. They were starting to come down. I flagged them, told them, you know, they can't come over here, over towards this area. But they continued to walk over anyway. They were coming from all the way down the other end of the block, all the way up towards Pike Street,
Okay.
walking down towards my direction from the other side of the street.
And what happened with those two males that were coming from Pike?
I stopped them, but I told them to get on a step a couple blocks down, a couple houses away from where the shell casings were. As other officers were arriving, because we came over the air saying that we had gunshots.
Yes.
As other officers were arriving, I had two other officers stay with them males while I went over to check. I went to the one porch, I forget the address.
Okay.
There's a grassy area in the front by the sidewalk.
Yes.
I took my flashlight out. I searched that area. And that's when I came upon the gun.
Okay. The two men up the block, were they anywhere near the bush or the
No,
tree at the time
I
of the
stopped
shooting?
them a couple houses away from
Okay.
that.
And you said that you used your flashlight to search the bush?
That's correct.
Okay. Once you found the gun, did you continue searching in the bush?
I searched that whole area. I searched that property and the property next to it. They both have grassy areas in front of them,
Okay.
just to make sure. And there was nothing else found in any of that area.
So you didn't find anything else in the
Nothing.
bush? Was there anything else about the bush that indicated to you whether the gun had been thrown or placed there recently or had been there a longer time?
No, it wasn't there long because the grass was pushed down, like the gun actually pushed the grass over, like the weeds over.
Okay.
It wasn't like I had a rubbish drill and like pull weeds out to look under.
Okay. Once you found the gun, what did you do with it?
I cleared the gun
Okay.
by
I'd like to show you what has been marked Government Exhibit 2, and I'll ask you if you recognize this.
I do.
Government would move to admit Government Exhibit 2. You said you cleared it, so the first question I have for you, is that gun safe here in the courtroom? for
That's
all of
correct.
us?
It's cleared.
Okay, and why is it safe, besides that you cleared it?
Well, I could tell because the slide is locked to the rear.
Okay. Any other reason? Did it
Well, it
have
doesn't
that?
have a magazine in it.
Okay. And did it have that red strap on it?
No, the red strap's holding it open at this
Okay.
point.
What the purpose of the red strap is what?
To hold it holds the slide to the rear. Basically, it's inoperable with fire at this point.
Okay, that's great. Now that we know that the gun is safe, could you, if you could stand up and actually pick up the gun and show the jurors, understanding that the red strap is on, what you do when you say you cleared it and made it safe?
Well, the slide would normally be locked to the front. In order to clear it, there's a button here. You would hit this button and pull the magazine out. And the button, when you pull the magazine out, the next round that would be on top would be the next round that fires. There's always one in the chamber. So in order to clear the chamber, you actually have to pull this back, and there's a button here on the side here. You push this up and pull this back, and it'll lock the front, the slide back, and the actual round that's in there ready to fire next would pop out. So there'd be nothing else left in the gun itself.
Okay, thank you, officer. You can put that down. I'd like to show you what has been marked Government Exhibit 3. I'll ask you if you recognize those.
Yes, that's the 2 rounds.
Okay, and when you say the 2 rounds, where did you see them?
The 1 round was actually in the chamber, which would be this would be the next round that would be fired. Then there was another one, and that one was in the magazine.
Okay,
And that was only loaded with 1 round and 1 round in the chamber.
okay. Did you put the magazine back in the gun after you cleared it?
No.
Okay, so what did you do with the gun?
Once I found the gun and the magazine, I cleared it and I put both of them in my pocket, my back pocket,
Okay.
out at the scene.
And what did you do with the ammunition that you just showed us?
The ammunition was put in my pocket too.
Okay. All right. I'd like to bring up Exhibit 26. And Officer McEwen, that has been admitted, so that should come up on your screen now as well.
Okay.
And if you could just indicate for us where you first saw the defendant. I'm just going to move back here so I can see the screen as well. Okay. Indicating for the record in front of the large tree in the photograph. And now could
Just
you
to the
also-
front of the tree.
Yes, exactly, just to the front of the tree. Could you also indicate on this photograph for us where it is that the defendant was stopped and arrested?
Approximately here somewhere.
Okay.
I think that's where he was originally stopped.
Okay, so indicating within about a house of the sign pole without a sign on it. All right, thank you. You could just try to press that exit button and clear it again. Later that evening, did you put that gun and the ammunition for it on a property receipt?
That's correct.
Okay, could you look in the binder at what has been marked Government Exhibit 10? That document's titled Property Receipt Number 298-03363. Is that the property receipt for the gun and ammunition?
No, it's 298-3363, no 0.
Yeah, you're right. Yeah, typo there. Thank you. Did you prepare that property receipt yourself?
That's correct.
Okay. Now, who did you give the firearm and the ammunition to once you left the crime scene?
The only other person that touched that gun was the detective to
Okay.
take pictures of it.
And by detective, who is that?
He's the
Assigned detective?
assigned detective. you're
Okay,
correct.
thank you. And you said he photographed it. Does he do anything else with it?
He would take pictures of the ammunition, he would measure it, and then he would run a trace for me to find out if it's stolen.
Okay. And what happened to the firearm once the assigned detective was done with it?
It went back in my pocket, and then we have to drive to another location, which is 8th Poplar, and enter it into evidence.
Okay. And what is it at 8th and Poplar? Why is it that you're taking it there?
That's our the firearms, where we turn in firearms at.
Okay. So that's part of the police department. You
Correct.
take it there.
It's
Okay.
it's our forensic lab.
Okay, thank you. Now, while you were going back to while you were still on the scene, before you took the gun there, while you were still on the scene at the 3800 block of North 17th Street, did you find any other evidence, or did you see any other evidence at the scene that this gun had been fired?
Yes, there were several empty FCC cartridges on the ground,
Okay,
which means they were fired.
and do you recall where you saw them?
They were approximately right where that tree is, on the ground, right in front of that tree.
Okay, so
Got Exhibit 26.
let's bring that photo back up.
Which exhibit?
Oh, 29, let's bring up 29. Could we bring up photo 29 for both Officer McEwen and the jury? Could you indicate there for us where it is that you saw the casings? Okay, indicating in front of the tree. So where was that in relation to where you first saw the defendant?
That's where the FCCs were found. The defendant was approximately like right here.
Okay, so indicating, am I correct, within about a foot?
Approximately.
After you found the gun in the bush, and after you saw the casings on the sidewalk, what did you do next? Did you go anywhere else at the scene?
No, I was still out at the scene the entire time
Okay.
until the scene was secured.
Okay. Did you go on into any of the houses or on any of the porches?
The only time when I went up on one of the porches to talk to my supervisor.
Okay. And did you see any evidence of any shooting there?
Yes, he was looking at this porch right here, if I can mark it. There was a strike mark on the door.
Okay, indicating the house right next to the tree had a strike mark on it. Could we bring up Exhibit 32? Do you recognize what's depicted here?
That's a strike mark on the door.
Okay, and that's on the door frame?
That's correct. It's like a steel frame door.
Did you see anything else at the scene, at the 3800 block of North 17th Street that night, that indicated that shots had been fired? Other than the casings, other than the strike mark on the door frame?
I personally saw another vehicle down the street that was struck.
Okay. You saw...
The back window was shattered out.
Okay. All right. Thank you, Your Honor. Officer McEwen, I have no further questions for you at this moment.
All right, cross-examine.
Morning, officer.
Morning.
You were working the 6 to 2 shift with your partner, Officer Terry, that day?
That's correct.
And 11:45, you were at the scene of 17th and Butler, correct?
That's correct.
And it was dark that evening? It was a hot summer evening?
Yes.
Okay. I want to show you how to turn to Exhibit 20, please. That's, isn't that 17th and Butler, or?
Hard to tell from that picture.
Okay. Well, the lighting on 17th and Butler, wouldn't it reflect accurately what the lighting was on the evening of August, the evening of the incident?
That's a negative.
It wouldn't?
No.
Would it be
Because
more
it looks like
lighting?
there's a flash mark going off in the picture.
Okay. So it'd be less lighting?
No, because there wouldn't, I mean, I'd be able to tell you better, but there was no glare in it.
Well, given what we have,
I could see the tree and everything in the background,
I see. So it'd be a little bit more lighting?
probably.
Okay. How much more lighting?
Well, it would have the overhead light from the street.
I see. And how many overhead lights are on the street, do you know?
No, I couldn't tell you.
Okay. But there's a lot of trees on the street too, correct?
I believe there's only trees on one side of the block.
Right, exactly. And that's where everyone's parked, on one side of the block
Correct.
too. And the incident occurred on that side of the block where everyone's parked.
That's correct.
Okay. And you indicated that you saw Mr. Seals throw an object.
That's correct.
Okay. But you also heard him say, "They're shooting at me, they're shooting at me."
That's correct.
And he ran towards you, correct?
That's correct.
He didn't run away from you.
No.
Was he shot?
No.
During your investigation, do you know that anyone take a gunpowder residue test to see if he had any gunpowder residue on his hand?
No.
Okay. Did he smell of gunpowder?
No.
Okay. I see. Now, the person who...
Can I...
No. The person who, you saw an individual run into a house?
I did not know.
You did not, your partner did.
That's correct.
Okay, do you know the name of that individual?
No, I do not.
Did you subsequently find out the name of that individual throughout your investigation?
No.
Okay. No further questions, Your Honor.
All right, redirect.
Very brief, Your Honor. How often do you do a gunpowder residue test on someone that you arrest?
Never. No, we've never done them. I don't even think the,
Objection, Judge, as to what he thinks. He
I-
answered the question.
as a,
Well, just a minute. Wait. Okay. What's the ground for the objection?
Speculative, what he thinks.
Okay, rephrase the question. Objection sustained.
Certainly, Your Honor. Do you know if it's police department procedure to do some kind of gunshot residue test? on
No,
the
it's not
person?
Judge,
procedure.
I don't see the relevance of that at all.
No, that he can overrule that.
You can answer that.
no, it's not procedure.
Thank you, officer.
No question.
Speak for us. But thank you, officer. Next witness, please. Well, tell you what, we'll take our mid-morning recess at this time. All right, ladies and gentlemen, we're going to take a recess for about 10 minutes. I've been advised that the noise has hopefully been stopped. There's some construction work going on. I'm sorry for that, but hopefully it will not continue. All right, so we're going to recess for 10 minutes, and as we told you, remember, please don't discuss the case. And we'll be 10, 12, 15 minutes. Then we'll probably go until 12:30 for lunch and recess. Thank you very much. Karen?
All rise.
Thank you. And no, let me just get an idea of what witnesses you have coming.
Certainly, Your Honor. Next witness up is the assigned detective, Detective Kremen. After that is the firearms examiner, Ron Whiteman. And the last witness is crime scene investigator Trenwith. And that is it from the government. We have a number of stipulations between the parties, but otherwise that's
You'll
it.
do the stipulations after the witnesses?
That was my thinking, Your Honor. We're happy to do them
All right.
whenever.
Okay, so we'll see where we are at the conclusion of this.
I'll just have cross-examination for Detective Kremens. The other two, maybe a few questions. So I'm saying that for purposes of housekeeping, because we may be able to rest.
Well, it sounds like the government's going to finish before lunch.
Yes.
Now, and the question is, if that's the case, so you're not calling any, you don't have any, is the firearms witness going to give any expert opinion?
He is going to give an expert opinion. He's going to give, it should not be long, he is going to just testify based on his report in which he says that the casings on the porch match the gun in the bush, the casings on the sidewalk match the gun in the bush, and the casings on the porch match the gun in the house.
I've stipulated to that.
Yeah, I
Obviously, it's the government's
To the
right.
operability.
Obviously, it's the government's right to bring
Okay.
it on.
All right, so I'm not going to make you, well, then when the government's rested, then you'll tell me what you want to do.
Correct.
And, but if we're done with the evidence, then we'll do the arguments after lunch, but.
Certainly.
Okay.
I'm just talking from perspective of a charge conference, because I know that's going to be very.
Well, we'll have a charge conference before we adjourn for lunch. if there's
Okay,
nothing to be
fine.
contested.
That's really where I'm coming from. Okay,
Thank
thank
you.
you, thank you.
Okay.
Thank you.
All right.
I'd just like to step out, Your Honor, go to back.
Yes, 10-minute recess, thank you.
That's always good.
Please.
You want credit?
Oh, yeah.
So she puts the numbers on the exhibits too.
No.
Yeah, touched on that.
Oh, no, I'm sorry. She does the photos. Yeah, but she does the photos.
I'm just going to go to him before the photo.
No, you can't do the photos.
No, I'm not asking, you know, the interview veteran gives him. Okay.
Give it.
Give it. You can show the photo, Brian.
You can't.
Oh, go ahead, you ask me. I can't ask him.
You can't.
Well, I want to get clear on it before.
Yeah, I wasn't ready to
Your
say.
Honor? May we approach, please?
What?
May we approach?
Yes.
Sorry. I want to be clear on this. Honor's, I want to get clear on your Honor's ruling before I cross-examine Detective Crimmins.
Yeah.
Okay, my understanding was is that I'd be able to ask him to interview Reginald Gibson. Gibbons. And, did you show him the photo back?
Yeah.
And that's it.
You can answer that.
Yeah.
Do you have any objection to that? If that's as far as it goes.
Yeah, well, yeah. I'm going to ask him, well, what is it? I'm going to ask him, what is a photo?
Yeah, sure.
That's it, yeah, that's it.
Okay. All right.
So this, we talked about this issue.
Please be seated. I'm sorry.
So she had an objection. Yeah, I told him what to answer. I told him this is what I was going to ask him.
All right. Okay, my only ruling was he can't testify as to what someone told him.
I understand. That's why I get clear on it. That's why I ask him.
All right, next witness, please.
Please raise your right hand. You do swear and or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God, and will you do so?
I do.
Please state and spell your name for the record, sir.
Detective Joseph Kremen, C-R-E-M-E-N, badge 9052, signed Northwest Detective.
Thank you.
Thank you.
may be seated. Please state your name.
Good morning, Your Honor.
Good morning, Detective Kremen.
Good morning.
How long have you worked for the Philadelphia Police Department?
12 and a half years?
Okay. And you said you're a detective?
Yes.
And how long have you been a detective?
6 years?
Okay. And just very briefly, could you tell the jurors what your responsibilities are as a detective?
As a detective, I investigate all types of crimes from burglaries, robberies, missing persons, aggravated assaults. The only thing I do not investigate are homicides or any kind of sexual offenses.
Okay. And about how much of your work relates to illegal firearms?
I'd say weekly. I deal with a firearm on a weekly basis.
Were you on duty last summer on the evening of August 10th, 2011?
Yes.
Okay. And do you recall what shift you were working?
I work the overnight shift from 11 p.m. till 7 in the morning.
Okay. So on that evening, were you assigned to investigate a shooting that took place shortly before midnight on the 3800 block of North 17th Street in Philadelphia?
Yes,
And as the assigned detective, did you go to the scene to process evidence?
I did.
Okay. Which addresses did you go to on the 3800 block of North 17th Street as part of the investigation?
I believe 3834, 3846, and I think 3844.
Okay. And what kind of buildings are at those addresses?
They're row homes.
Okay. Private residences?
Private residences, yes, single homes.
Now, approximately what time did you go to the scene?
I got at the scene shortly before the sun came up. I would say around 5 a.m. or so.
So, although the shooting you were investigating happened shortly before midnight on August 10th, you really went there in the early morning hours of August 11th. Is
Yes.
that correct?
Yes.
Okay. And why did you wait a number of hours before going to the scene?
Well, I had to obtain a search warrant for the property there.
Okay.
So that takes time to prepare a search warrant.
Now, from the time that Officer Terry arrested the defendant and you were assigned to this case until the time you got there, how was the scene protected, or was it protected?
There's officers that were out there holding the scene.
Okay, and by holding the scene, can you describe for the jury what that means?
From what I recall, there was at least 2 officers that were there. The crime scene tape goes across the highway, and there's officers standing out there preventing anybody from entering, disturbing the crime scene.
Okay. When you arrived at the scene, did you take photographs of the scene?
I did.
And did you also take some photographs at the police station of evidence that had been brought to you from the scene?
I believe I did, yes. Yes.
Okay. Before you went to the scene, what evidence did you receive from the officers?
Firearm.
Okay. I would like to show you. I'd like to show you what has been marked Government Exhibit 2 and ask if you recognize that.
Yes, this is the firearm that was recovered from the officers that night.
Okay, and also Government Exhibit 3. Take those out of Government Exhibit 3. And do you recognize that?
Yes, they're live .380 rounds.
Okay. what did you do with that firearm after you first received it from Officer McEwen?
First thing I did is make sure the firearm was unloaded and safe before I handled it.
Okay, and how do you do that?
Well, you make sure that there's no magazine inside the firearm, and then you take the top, which we call the slide, and rack it back, making sure that there's no ammunition inside the chamber.
So obviously the red strap was not there.
Correct.
At the time. Okay. When you got the gun from Officer McEwen, had it been preserved for fingerprints at that time?
No.
Okay. When you received the gun from Officer McEwen, did he tell you the circumstances in which he had recovered it?
Yes.
And in those circumstances, did he follow normal police procedure by recovering the item?
Yes. The gun was recovered from the highway. There's certain circumstances which you would not recover it, but in this case, it was recovered and brought to me.
Okay. Once you had the gun from Officer McEwen in your possession and you checked to make sure that it was unloaded, what did you do with it next?
I attempted to recover a serial number from the firearm so I can conduct a record check to find out who might have owned it. At the time, I could not find a serial number on the gun.
Okay. And when you say you tried to recover a serial number, what would that involve? Could you show us on the gun?
Yeah, normally the firearms, they have serial numbers on it. On this firearm, it appears to be on the left-hand side of the gun, which would be right around here. To me, the firearm the serial number had been obliterated, which means it's scratched off. So I couldn't read the serial numbers on it.
Okay. And then what else do you do besides look for the serial number?
After that, you have to send a report into the ATF, which is they call it a trace report. That information gets sent with the gun down to 8th and Poplar, where the firearms identification unit is.
Okay. And when you were done processing the gun, what did you do with it?
It was given back to the officers along with the report that needed to go with it. They took possession of it.
Okay. Now, I think you said that on the night of August 10th, you obtained a search warrant for one of the houses on the 3800 block.
Yes.
Okay. Could you take a look at Exhibit 27? There's a binder in front of you?
Yes, there's a binder here. Yes.
And do you recognize what's in that photograph?
It's a picture of the front of the property,
Okay.
3846 and 3844.
I'd like to ask that Exhibit 27 be shown to the jury.
Yes, a minute.
Okay. And I'm sorry, it showed what?
It's the front of the 3846 along with 3844.
Okay. And do you recall which was the house in which you had a search warrant?
3846.
Okay. Thank you. And what, if anything, did you find in the house that indicated there had been a shooting in that area?
Well, first on the 3844 on the porch in front of the door, there were 2 FCCs, which is fired cartridges from a gun, along with a projectile. And inside 3846, in a second floor bathroom, there was a firearm recovered, .40 caliber, I believe.
Okay. Could you please look at what has been marked Exhibit 11? That's in the binder. A property receipt, number 2979858.
Yes,
Is that your signature on the property receipt?
it is.
And what items did you place on this property receipt?
Taurus .40 caliber semi-automatic handgun, black in color with black rips, along with 7 .40 caliber stainless steel ammunition, live rounds. The item 3 were 5 .40 caliber Smith & Wesson ammunition.
Okay. And you said you also found casings on the porch at 3844?
Yes.
Okay. And what, if anything, did you do with the 2 casings on the porch? And also, you said by projectile, is that a bullet?
Yes.
Okay. What, if anything, did you do with the 2 casings on the porch and the bullet?
They were placed on a property receipt and submitted to the firearm identification unit.
Okay. Can you please look at Exhibit 12, which is a property receipt number 2979859? Is this the property receipt you prepared for the 2 casings that were found on the porch?
Yes.
Okay. When you found those casings on the porch of 3844, did that indicate to you where the person who shot the gun that the casings came from would have been?
Yes. They would have been standing in front of 3846.
And why is that?
Well, with a firearm, all firearms have the ejector port on the right-hand side. So when you fire a gun, the projectile the fire cartridges gets shot out to the right, and usually it's backwards. So considering that the two FCCs were found in front of 3844, the person had to be standing to the left of that.
Okay, thank you all. In addition to the gun that you found in the house and the casings and the bullet that you found on the porch, did you find any other evidence of a shooting at the scene?
On the sidewalk, I don't recall the exact address, there were, I believe, 2 FCCs on the sidewalk, and there was a bullet hole inside a parked vehicle not too far from there.
Okay, I'd like you to look at Exhibit 29 in the binder. And tell me if you recognize that location.
Yes.
And if 29 could be brought up for the jury as well. Okay, and could you tell us what you found at this location?
There were 2 FCCs found on the sidewalk.
Okay, if you look at it on your screen now, you should be able to just touch it and indicate for us approximately where you saw the casings.
From what I recall, they were somewhere in this area right here.
Okay, indicating for the record in front of the tree and somewhat close to the bush.
Correct.
Okay, and there's a little exit or erase key on the bottom left. Okay, and what, if anything, did you do with the casings that you found on the sidewalk?
They were placed on the property receipt.
Okay, and if you could look at what has been marked Exhibit 13 in your binder, a property receipt number 2979860.
Yes.
Is that your signature?
Yes.
And is that the property receipt that you
Yes, it is.
prepared? Okay. When you saw the discarded casings on the sidewalk in front of 3842, did that indicate to you where the person would have been when they shot the gun that the casings came out of?
Would have been to the left of that,
Okay.
on the sidewalk.
Approximately how far away in distance?
Well, in this case, since it's on the sidewalk, FCCs, when they're discharged from the weapon, won't go more than, I would say, 4 or 5 feet.
Objection, Judge, he's giving an opinion.
I'm going to rephrase the question. That answer will be stricken.
Okay. Thank you. You saw the casings on the sidewalk.
Correct.
Did you know, based on your experience with a semi-automatic weapon, approximately where the person would have been when they were
Objection
fired?
again, Judge. Goes for an expert opinion.
No, well, not necessarily. Can you answer the question?
Yes.
Just based on your experience with
From my
semi-automatic
experience
weapons.
from firing every year, training with my weapon, no more than about 6 feet.
Okay, thank you. After you had put all of this evidence on property receipts, what did you do with it?
It was taken down to our firearms identification unit.
Okay, and I believe you said you also saw a vehicle that had been struck?
Yes.
Okay, can you tell us what, if anything, was done with regard to that vehicle?
The vehicle was photographed, and I made an attempt to find the owner of the vehicle.
Okay, thank you, Your Honor. I have no further questions at this time.
Yes, exactly.
Good morning, Detective.
Good morning.
In regards to this investigation, did you have an opportunity to interview Mr. Reginald Gibbons?
Yes.
And was Mr. Gibbons the person who resided at 3846 North 17th Street?
I wouldn't say he resided there, but he had ties to that
Had
house.
ties there. And when you executed your search warrant, did you find a weapon at that residence?
Yes.
And in your interview of Mr. Gibbons, did you show him a photo array?
Yes.
And what is a photo array?
A photo array is a piece of paper that has 8 photographs on it. That's typically shown when you have a suspect in mind and you want to put that photo along with 7 other photos in an attempt to identify someone that was responsible for a crime.
Okay. And you indicate that in your direct testimony, you indicated that the weapon was not preserved for fingerprints. Is that correct?
You're referring to this one?
Yes.
Yes.
Regarding the weapon that police officers took,
Correct.
received from the bushes.
Right. It was not preserved.
Okay. Thank you very much.
Redirect?
Yes, very brief, Your Honor. Yes, Detective, why was the gun not preserved for fingerprints?
Objection, Judge. He doesn't know that. It's purely speculative.
Well, you can first of all ask him if he knows of his own personal knowledge.
Yes, I will do that. In your experience as a detective, how often do you send a gun to be fingerprint
Again,
tested?
Judge.
Well, so stay. You can ask him if, in this case,
Okay,
if there's any reason why he didn't submit this gun for fingerprints.
Detective, is there any reason why in this case you did not preserve this gun for fingerprints?
It had already been picked up by the officers and therefore it was already contaminated by their fingerprints and touching it.
Okay. Can you tell us in your career how many times you have gotten a usable fingerprint from a
Objection,
firearm?
Judge. He's not
Yes,
testifying as
sustained.
firearm.
It's not relevant.
Okay. No further questions.
Thank you. Recross?
No, Judge.
All right, thank you.
Thank you, Your Honor.
Next witness.
Okay, we will call Sir Whiteman.
Please raise your right hand. You do swear and or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God, and or you do so affirm?
So help me God.
Please state and spell your last name for the record, sir.
Name's Officer Whiteman, spelled W-E-I-T-M-A-N. First name's Ronald, badge number 2132, assigned to the Firearms Identification Unit.
Thank you, sir. You may be seated. Please state your name.
Good morning, Officer Whiteman.
Good morning.
You said you're with the Firearms Identification Unit. Could you tell us where that unit's located?
It's what we call 8th and Poplar, which is 843 to 849 North Poplar Street.
And how long have you been a Philadelphia police officer?
Going on 18 years.
And how long have you worked in the Firearms Identification Unit?
Since 2007, so it's probably going on my 6th year.
And what is your position there?
Firearms examiner.
Okay. And can you tell us what the Firearms Identification Unit is? Can you just briefly describe for the jury what's done there?
Okay, well, what we do is identify any evidence submitted from Philadelphia, such as firearms and ammunition. And what we do is identify for the country, the country of origin, the caliber, the make, and then we proceed to bench check different firearms, such as to safe operations, making sure the firearm hasn't been altered from manufactured design. Once we bench check our firearms, we have to test for operability. Now, when we test for operability, we either compare any test shots against any evidence submitted, or we entered the test shots into what we call the Integrated Ballistic Identification Database, which is known as IBIS. But again, our primary function is microscopic examination on any evidence submitted, such as bullets, cartridge cases, and other ammunition components, and to make a determination whether it came from a particular firearm. Other procedures we might have to do is trajectory studies to help assist in crime scene reconstruction. We might have to do gunshot residue patterns by the use of residue and shot patterns, or distance determination, which I meant to say. We also, if a serial number has been obliterated, we are trained in different methods on bringing back that serial number. We may do trigger pull tests, drop safety tests.
Okay. Thank you, officer. About how many guns a year come into your unit for some kind of examination?
At least 5,000 to 6,000.
Okay. And what training or education have you had that qualifies you to perform these duties?
Well, our training, when we first signed the Firearms Identification Unit, we most likely go through mostly 18 months of in-house training. Now, we were fortunate enough to have an outside consultant agency, which were retired New York firearm examiners that trained us. Well, they trained us through the same phases that the Association of Firearms and Tool Marks examiners go through. And that's a bunch of different phases where we start from the beginning, where we learn the history, we go into the nomenclature of firearms, how each different firearm operates, like pistols, semi-automatic, revolvers, shotguns, and even homemade devices. Once this part of our phase of training is over, which takes about, I would say, the first 6 months, then they'll send us up to firearms manufacturers. Now, each manufacturer has their own technique of making firearms. Why they send us up there? Because they want us to learn how a firearm is actually made. We're assigned a chief engineer where we're taken around and we actually watch a bar of steel get pounded into a mold that looks like a firearm, then cut into its shape and into its parts itself. Why they do this for us? Because we're learning the tools about tool surfaces, of how tool surfaces apply to firearms. And when these tool surfaces are applied to the firearm itself, they tend to leave unique marks behind, which distinguish it from all other firearms. Now, once we finish this phase, then we get into the phase of microscopic examination, where once we get back, we learn how to use what we call a comparison microscope. Now, comparison microscopes are two microscopes that are optically bridged together, where you can simultaneously observe two pieces of evidence at the same magnification. Now, once we get back, and like I told you, the unique marks are left behind, we cannot see by the human eye, but under the comparison microscope, we can see these marks. Then we're assigned over 200 practice cases at the time, which consists of over 1,000 pieces of evidence.
Okay. Have you testified in the field of firearms examination before? Firearms examination and identification?
Yes.
Okay. Approximately how many times have you testified before?
I've done it 32 times.
Okay. And in which courts have you testified?
Criminal justice.
Okay. And were you qualified as an expert whenever you testified in court?
Yes.
Okay. There's a binder in front of you. If you could look at Exhibit 43 in the binder. It's all the way at the back. Is this your CV detailing the training that you have just told us about?
Yes, it is.
Okay. Your Honor, the government offers Examiner Whiteman as an expert in firearms.
There's no
Do you
objection.
have any questions?
No, Judge, I've already stipulated to this.
Okay, ladies and gentlemen of the jury, just one small, short instruction about this. Most witnesses who testify as to facts. that is what they saw and what they did, and so forth. But the law also allows other witnesses who have specialized training to give opinions, and these are sometimes called opinion witnesses or expert witnesses. By reason of their training and expertise, they're allowed to testify not only as to facts, but also to give opinions based on the facts that they observe and their experience and knowledge. So this is such a witness who, by his training and experience in firearms, is qualified as an expert in firearms and may give opinion testimony. Now, with any witness, the credibility of the witness is for you to determine. You may proceed. Thank you.
Officer Whiteman, this is actually up here, Government Exhibit 2. I'm going to give it back to you and ask you if you have seen this before.
Yes.
Okay, and under what circumstances did this firearm come into your possession?
This firearm came into my possession when I was assigned to this on the dates.
Okay. Did you prepare a report on your examination of this firearm as well as other evidence in this matter?
Yes.
Okay, and if you could look in the binder at Government Exhibit 15.
16?
15.
60?
15, 1-5.
15. The tabs are high. Okay.
All right, do you recognize this document?
Yes.
Okay, and is that the report that you prepared?
Yes, it is.
Okay. Did you perform an examination on that firearm?
Excuse me?
Did you perform a general examination of that firearm?
Yes.
Okay, and how is it that you know that it's the same firearm?
Well, anytime it's the same per firearm as by the property receipt itself. Each firearm is assigned to a property receipt, and that unique number will follow this firearm through its chain of custody.
Okay. You mentioned chain of custody. From the time that a firearm is recovered at a crime scene until it comes to you, how many people handle it?
I can give you an estimate how many people, with the officer itself who actually put it on the property sheet, and then the detective who actually maybe ran the serial number, and then once after that's done, then it's taken down to 8th and Popular, where it's dropped off for one of the windows for custody, where it might be actually a third person. I would have to say 4 or 5. Then they come transfer from upstairs to downstairs to 3 people downstairs. I would have to say, and then to me, it'd be probably the 8th or 9th person.
Okay, thank you. Now, when a semi-automatic firearm is fired, what happens to the casings that are expelled? Where do they go?
Well, with a semi-automatic pistol, now when we're talking about casings, we're talking about a cartridge. We're talking about a component, part of the components. Now, a cartridge case has 4 components to it. We have what we call the primer. We got the cartridge case itself. Then we have the projectile, and then we have the powder. Now, what happens when you actually load the magazine well into the magazine into the magazine well, what happens, you pull back and you are going to strip off one cartridge off that magazine. Now the gun is going to be ready to fire. Once you pull that trigger, what happens to that trigger is that firing pin is going to come in contact with what we call the primer, which makes that spark, ignites that spark. That spark's going to ignite the gunpowder, where the powder itself is going to become high combustible gases, which is what allows the projectile to go down to the barrel, and also wherever there is an action, there's a reaction. So them same gases is going to actually force the slide to the rear, and the extractor itself is going to grab the cartridge case, pull that out, hit the ejector, and come out to use normally to the right and to the rear.
Okay. And about,
And each time you fire, it will strip off a new cartridge until you exhaust all ammunition.
and about how far away would the casing be from the gun that it was fired from?
If the gun is held properly, it can, because this is a 380 auto, it can be 3 to 6 feet to the right.
Okay.
To
Now,
the rear.
since you are holding the gun there, could you explain to the juror what type of gun this is, what the make and model are?
This is what we call a Star. This is made in Ivor, Spain, right? And they give it a model number as a SS. We have a stainless steel and it's what we call a barrel with, I believe it's 6 right, if I'm
And
not mistaken.
what, if anything, does the firearm say on it? Are you reading something from on there? On the firearm itself?
Yeah,
does-
all manufacturers' markings are on the firearm itself, where it says Star. Even the importer itself is on here.
And can you read that to the jury? Does it have the importer on it?
Yes, the importer's Inner Arms, which is located in Alexandria, Virginia.
Okay, and does it say anything else on the firearm?
Let's see here. Star, and then Spain. From up.
Okay.
And then on the bottom is their, what they consider the model. They just call it the SS.
Okay. What is the maximum capacity of this model?
This one, I believe, is 9+1.
Okay. And do you know how many bullets were in this gun when it was recovered?
When I received this firearm, I don't know how many, when I received the firearm itself, I received the loose cartridge.
Yes, and how many loose ones did you receive?
And I believe I received 2, 3.
If I may approach.
I received 2 of them. One was what we call the manufacturer of a CBC, and one was what we call a PMC, which they both were what we call full metal jacket of a caliber of 380 auto.
When you received this firearm, were you able to read the serial number so that it could be traced?
No, this is a firearm when I received, that's the first thing I did notice, that the serial number has been obliterated.
So were you able to recover a serial number?
Yes, I have.
And what did you have to do to recover the serial number?
Okay, to recover, like I said, we were trained by ATF on different methods on recovering serial numbers. Now, this one, the recovery, because this bottom part of the receiver is also what we call ferrous, which is magnetic. Now, when a serial number is punched in on the frame itself, what it's doing is they might destroy the surfaces, but actually it's displacing the steel molecules inside of it. So once we put a magnet here, underneath here, the magnetic, and then we have a liquid magnetic particles, and we actually drop the particles on. Well, the magnetic particles are going to go to that compressed area, because it's the first thing that's magnetizing right through. Just like if you remember, you know how an old etching board is, but they use the powder magnet, and you just move that thing around. Well, this is already, consider this already etched, and I already have the magnetic field underneath, and the magnetic particles will draw to the numbers, and it will actually bring up all the numbers.
Officer Whiteman, could you tell us, please, tell the jury what the serial number was that you were able to recover from this firearm?
Okay, the serial number was I did leave my reading glasses behind. 1908948.
Thank you. And I believe you said that you had an opportunity to examine the firearm. Did you also test fire it?
Yes, I did.
And was it operable?
Yes, it was.
Based upon your examination and testing, in your expert opinion, is this weapon capable of expelling a projectile by the action of an explosive?
Yes.
And it does meet the federal statutory definition of a firearm?
Yes.
Okay. If you would look at Government Exhibit 13.
Okay.
Got 13, okay. A property receipt numbered 2979860 for 2 fired cartridges found on the sidewalk near 3842 North 17th Street and a bullet found on the porch of 3844 North 17th Street. Did you receive those 3 items for testing?
Yes.
Okay. Did you examine the 2 casings that came from the sidewalk in front of 3842?
Yes.
And were you able to determine if those 2 casings on the sidewalk in front of 3842 had been fired from Government Exhibit 2, the .380 firearm you just told us about?
Yes.
Okay, so those...
They were fired in.
They were fired from that gun?
Fired into the gun, yes.
Okay. Did you examine the bullet found on the porch of 3844?
Yes.
And were you able to determine if the bullet on the porch at 3844 had been fired from Government Exhibit 2?
Yes, it has.
Okay. I'd also like you to look now at Government Exhibit 11. It's at the front of the binder. Okay. Government Exhibit 11, a property receipt number 2979858 for a .40 caliber semi-automatic Taurus firearm recovered during a search at 3846 North 17th Street on August 11th. Did you examine that weapon as well?
What exhibit you were?
We are on Government Exhibit
Okay.
11,
There it is.
property receipt.
Okay.
Got it?
Got it.
Okay. And did you examine the weapon that's listed on that property receipt, a .40 caliber semi-automatic handgun recovered during a search of 3846 North 17th Street?
Yes, I did.
Okay. And what was the maximum capacity of that gun?
That gun was... Okay, that capacity was 15 plus 1.
And what does that mean?
That means that when we're talking about capacity of a magazine, the magazine actually, you know, once you fill the magazine with the capacity, we would insert it into the magazine, we would pull back the slide and actually chamber one, unload it and top it off and put it back in. That's where we pull 15 plus 1. So we got 15 in the the magazine and then 1 in the chain.
And was that firearm loaded when it was recovered?
Like I said, We get all our ammunition loose.
Yes. Did it come with loose ammunition?
Yes, it did.
Okay. Do you recall how many rounds?
That one came with, I believe, 12 cartridges.
And was that firearm operable?
Yes, it was.
Okay. Just one more here. Government Exhibit 12. The property receipt 2979859 for 2 fired cartridge casings from the porch of 3844 North 17th Street. Did you examine those 2 casings from the porch?
Yes, it did.
Okay. And were you able to determine if those casings from the porch of 3844 had been fired from the Taurus firearm found in 3846?
Yes, FCC 1 or FCC what was marked FCC 4, 3 and 4, which is 40 caliber, were fired in the Taurus, which was pistol P2.
Thank you, Officer Whiteman. No further questions at this time.
Or cross-examine?
None.
No questions? All right, thank you, officer. Next witness, please.
Please raise your right hand. Do you swear and or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God, and or you do so affirm?
I do.
Please state and spell your last name for the record, sir.
Police Officer William Trenwith, Trenwith, badge number 6298.
Thank you. You may receive it. Please speak into the microphone.
Good morning, Officer Trenwith.
Good morning.
Where do you work?
I work in the Philadelphia Police Crime Scene Unit.
Okay. And how long have you been a police officer?
I'm coming up on my 36th year in February,
How long have you worked in the crime scene unit?
for the past 20 years.
What are your job responsibilities as a crime scene officer?
My responsibilities are we go out to every homicide, every aggravated assault where there may be a chance of death, major robberies, burglaries, sexual assaults, suspicious suicides, some industrial accidents, or any time that one of our detectives from one of our divisions needs help in processing the scene, they will call us.
Okay. And when you say process the scene, what's involved, just briefly, with processing a scene?
When I process a scene, I basically go to the scene. I am the photographer of the scene. I collect all the evidence. I sketch it, usually to scale for a court preparation, and so I can present the drawings to a jury. I am the person that does all the latent examinations. We try to figure out trajectory, maybe footwear, tire impressions, molding and photography, all crime scene related things.
Officer, you just used the word latent. By that, do you mean latent fingerprints?
Yes.
Okay. Could you tell us what your training and experience is with regard to latent fingerprints?
In the 20 years I've been in the crime scene unit, I have been trained by the FBI in Quantico, Virginia, in latent fingerprint development and photography. I've been involved with the FBI where they came to our city and have done road schools. It's called road schools. They come and train us in some latent fingerprint work. In the 20 years that I've been there, probably the more senior examiners, when I got there, taught me different processing and different chemicals that we use in trying to develop and bring out fingerprints, and doing it on a daily basis. I've learned through the years of what works better and what doesn't.
You mentioned that you had learned from senior investigators in your unit. What is your level of seniority now in the unit?
I am the senior crime scene investigator with the city right now.
Okay. And have you testified in state court before?
Yes.
Approximately how many times?
A few hundred times, probably.
Have you sometimes been found to be an expert?
Yes.
Have you ever been found not to be an expert?
No.
Okay. Have you testified in federal court before?
Yes, I have.
Approximately how many times?
I'd say 5 times, maybe.
Have you sometimes been found to be an expert?
I don't think in federal court, no.
Okay. Have you ever been found not to be an expert in court?
No.
Okay. I would like you to take a look at the binder in front of you at Government Exhibit 45. I think it may be the very last exhibit in the binder. Is this your CV showing the training you just described to us?
Yes, it is.
Okay. Your Honor, I offer Officer Trenwith as an expert on crime scene investigation and fingerprint recovery.
Do you want to ask them any questions?
No, Judge.
All right, well, ladies and gentlemen of the jury, as I said with the prior witness, this gentleman qualifies as an expert to be able to give opinions based on his background and experience. So we should consider his credibility along with the other witnesses, but he'll be allowed to give opinions. Right.
Thank you. Officer Trenwith, please explain briefly to the jury what you mean by a latent fingerprint.
A latent fingerprint is, you've seen in many movies and TV, it's when your fingers or palms transfer a print onto a surface, which means it's a latent fingerprint. There's various reasons why somebody will leave a fingerprint and some reasons why somebody wouldn't. A fingerprint is basically made up of perspiration and some oils. Say if you touch your head, touch another surface, you'll probably leave a latent fingerprint. Or some factors that may determine that you may not leave a fingerprint if somebody has dry skin, the different surfaces may not retain fingerprints. In some surfaces are much better to obtain fingerprints than other surfaces. So,
well, can you give us some examples of what kinds of surfaces are good for leaving a latent fingerprint?
The best surfaces are mirrors, glass, smooth metal surfaces. Some paper products are very good. Anything that's smooth, clean, it's a great surface for a...
So what kind of surfaces are bad for leaving a fingerprint?
Any surface that has a texture on it or is a rough surface. You can't get a fingerprint off of, say this surface here. The texture on the side of this gun. Bad surface for a fingerprint. The way some firearms are made, the surfaces are made so that you can't get a fingerprint off of, especially the more modern guns, say the Glocks and the 6 hours. The manufacturer puts a surface on there, it's like a rough surface so that you can't get a fingerprint off of. And of course, like some movies that you've seen, I've seen movies where you could get a fingerprint off a rock. You can't do that, it's impossible. For the most part, the surface has to be clean, smooth, a smooth surface.
For the record, the witness was handling what is Government Exhibit 2, the firearm, the Starbani. Is the trigger on this particular firearm, Government Exhibit 2, ridged or smooth?
It is ridged, which also prevents somebody from getting a fingerprint off that surface.
And is the back of the slide ridged or smooth?
That is also ridged, and that's ridged for a reason, so that when you grab it and pull the slide back, there's a surface on there so that it makes a friction with your finger.
Officer, if there were a fingerprint on a firearm, but that firearm was then thrown into a large bush, what would be the effect, if any, on the fingerprint?
Fingerprints are extremely fragile. As I stated before, like TV and movies make you kind of believe that fingerprints are easily to obtain. They are not. They are extremely fragile. The services itself is tough, and the environment itself is tough. Say, as you just stated, you throw it into a bush. It's passing through 100,000, well, maybe 1,000 leaves before it hits the ground. Each one of them leaves is brushing against this gun and removing any fingerprints that could possibly be on it. Unfortunately, when a police officer picks it up, he picks it up in the same exact way that somebody probably threw it away. Therefore, touching the safe surfaces that there may be a fingerprint on that gun. If a fingerprint is on top of another fingerprint, that makes both fingerprints unidentifiable. You can't, I've seen in the movies where they've lifted one fingerprint off of another fingerprint in a computer, and you could identify both fingerprints, and that doesn't happen. You can't do that. Smudges and smears. For the most part, if you touch a surface and lift your finger up, straight up, you may get a fingerprint. If you touch a surface and so much as move it just a little bit, you're going to smear that surface and make it so that you can't get an identifiable fingerprint. There's many factors.
Is there an impact on any prints that were there if the officer who recovers it not only picks it up but also makes it safe by unloading it?
As I stated, the same person that fired the gun or threw away the gun touches an area, and the person that picks that gun up, like a police officer, is going to touch that same area. And for the most part, the police officers don't carry gloves with them, except for maybe getting involved in some scenes where there's blood and all that. But for the most part, he wants to pick that gun up, make it safe, and usually does it without gloves. So he's going to pick that gun up, he's going to make it safe, he's going to, if there's a fingerprint on the slide, he's going to push that slide back to see if there's any bullet inside. In the same motion that he's doing that, if there was a fingerprint on there, he's most likely destroying the fingerprint that is on there.
Officer, if the recovering officer made the gun safe and then put it in his pocket, would that have any further impact on any fingerprints?
Absolutely. A holster or a waistband of somebody's pants do the same exact thing as a finger does. It rubs against it and will rub off any fingerprints that could possibly be on that gun.
In your experience as a police officer, when you respond to a crime scene and there is a firearm on a public street, what is the first concern?
The first concern is making that firearm safe. And you want to get it, if there's people in the area, you definitely don't want to just have it laying around. You want to pick it up, make it safe, put it in your pocket, put it in your waistband, lock it in the trunk of your car. You just don't want to let it lay in there.
All right. You said you have been with the crime scene unit for 20 years. In your 20-year career there, how many times have you tried to get fingerprints from a firearm?
Every case that I'm involved in, usually if there's a gun at a scene, at a homicide scene, I will try to get fingerprints off of. We also are the people who, throughout the department, send their guns to see if we can get latent fingerprints off of. I examine hundreds of firearms, probably thousands of firearms evidence, like fire cartridge cases, bullets. And in the 20 years that I've been in the crime scene unit, I have gotten one identifiable fingerprint off of a gun. One. It's not a lot. And that's identifiable. I've gotten fingerprints, smudges, smears, which is also classified as a fingerprint, but I've only gotten one identifiable fingerprint off of a gun in 20 years.
Is it possible to get a fingerprint off of the fired cartridge casings that are expelled from the firearm?
No, that is, I don't know anybody who's gotten a latent fingerprint off a fired cartridge case unless it was already embedded in that cartridge case. The reason being is when a firearm is fired, that bullet heats up to several thousand degrees in a matter of a millisecond. And since a fingerprint is basically a liquid made up of perspiration and some oils, it'll evaporate anything on a fire cartridge case. I've never gotten a fingerprint off a fire cartridge case, although I do look at every single one, and I don't know of anybody else in my unit who's ever gotten a fingerprint off a fire cartridge case.
As the senior officer in the unit, do you know if the other officers in your unit have similarly low rates of recovery with regard to finding usable prints on a firearm?
In preparation for my testimony, I was asking around my unit to the other people who I work with how many fingerprints they have gotten off of firearms in the time that they have been here. The most I've come across was 3 identifiable prints off of firearms.
I'd like to ask you about one other matter. A gunshot residue test, is that something that you use at the scenes you investigate?
On some
Objection,
suicide...
Judge, I don't think he's qualified to answer that
Have you had
question.
experience with gunshot residue?
Many times. Many
Just
times.
describe what your experience is, or how that, explain to the jury what that means and how you test for that.
A gunshot residue, it's called an SEM test, scan the electron microscope test. It's for gunshot residue, GSR. We do these, we used to do them a lot more in the past than we do now. I haven't done any probably in the past year because we found out that there was so much cross-contamination on gunshot residue tests and the SEM test that we did. Say, for instance, if somebody's arrested and placed in cuffs by a police officer, that police officer has handled guns in the past. Those handcuffs have been placed on people who have used guns in the past. His hands are placed behind his back. He's then placed into a police car where it's a smooth surface. It's usually like a plastic surface in the back of his police cars. His hands then rub up against that surface where there have been probably hundreds of people put into the back of a police car who have handled guns. So we don't like doing it because there's so much chances of cross-contamination. You're liable to get somebody who's not handled a gun at all, but will come up positive. And we were finding that out, that through cross-contamination, that was happening more and more. So we don't do it anymore.
All right, I'll overrule the objection. You can ask.
I think he's answered the questions.
Okay. Well, just, all right, okay, go ahead, move on.
Okay, certainly. One final question. In your experience with firearms, if someone has fired a semi-automatic weapon like this one, and then they are at some distance a few feet away, would you expect to be able to smell gunpowder on that person?
No. And the only reason why I know that is because I've fired guns many times at the range. And after you're done at the range, you're sitting in the classroom, and I can't say I've smelled a smell of gunshots on somebody who's sitting next to me now.
Thank you. No further questions.
A few brief ones.
Sure.
Good morning, officer.
Good morning.
You indicated that that you've been a police officer, I think, for 36 years,
It'll be 36 years this coming February.
and you've testified as an expert numerous times, correct?
Yes.
And every time you testified as an expert, you testified for the government, correct?
That is correct.
And regarding fingerprints, in order for you to be able to obtain a fingerprint, the gun needs to be preserved for fingerprints, correct?
Right from the get-go, usually, yes.
Okay. And in this case, the gun wasn't preserved for fingerprints, correct?
From what I've heard, yes. No, it wasn't.
No further questions, Your Honor.
Redirect?
Nothing further, Your Honor.
Thank you. All right, next witness, please.
That's all of the witnesses that we have to present, Your Honor. We do have some stipulations between the
Okay,
parties.
all right, we'll now proceed with the stipulations. All right, ladies and gentlemen, stipulation is a fancy word for an agreement. It's not unusual in cases that both counsel will enter into an agreement or stipulation that a certain witness or witnesses will testify in a certain way. And usually that is done because there may not be any dispute about the matter, or it just may be a convenient way of getting evidence on the record. So listen carefully to the stipulations. What it means is that the attorney for the defendant and the attorney for the government have agreed this particular witness was clear that he gives certain testimony. So you may consider that there's no dispute about that testimony. However, as with all testimony, it's for you to consider and for you to weigh the testimony that is presented by the way the facts that are presented by those stipulations against the other evidence in considering the evidence in total and arriving at a verdict. Okay, you may proceed.
Okay, certainly. The parties have reached certain stipulations, and we have 6 of them. I'll read each one. The first stipulation that the parties have agreed to is that the firearm listed in the indictment, a Star Bonnie Echevarria .380 caliber semi-automatic handgun, model SS, serial number 1908948 Star, was loaded with 4 rounds of ammunition, has been test-fired and found to be operable. It is a firearm within the definition of Title 18, United States Code, Section 921A3. That is a weapon which will and is designed to expel a projectile by the action of an explosive. The second stipulation, stipulation 2, concerns interstate commerce, and that is that the firearm listed in the indictment, again, the Star Bonnie Echevarria .380 caliber semi-automatic handgun, model SS, serial number 1908948 Star, and the ammunition listed in the indictment, 1 CBC ammunition cartridge, 1 PMC ammunition cartridge, 1 PMC fired cartridge casing, and 1 Remington fired cartridge casing, were all manufactured outside the Commonwealth of Pennsylvania. By virtue of their presence in the Commonwealth of Pennsylvania on or about August 10, 2011, the firearm and the 4 rounds of ammunition had traveled in interstate commerce. Stipulation 3 concerns prior conviction and states that prior to August 10, 2011, defendant Bryan Seals had been convicted in a court of the Commonwealth of Pennsylvania of a crime punishable by imprisonment for a term exceeding 1 year. That is, he had been convicted of a felony within the meaning of Title 18, United States Code, Section 922G1. Stipulation 4 regarding the map was that the map that you see up there is a fair and accurate representation based on information from the Philadelphia Streets Department of the layout of the streets and location of the houses and other buildings on and around the 3800 block of North 17th Street in Philadelphia. Fifth, that there was an agreement as to chain of custody as to which person had the evidence at each point, and the parties agreed that from the time each of the government's exhibits came into the government's possession through the time of their introduction in evidence here, a proper and acceptable chain of custody was maintained, and the exhibits were not altered, tampered with, or modified in any way. And sixth and last, it is agreed that the photographs that are labeled Exhibits 17 to 24, which were taken by Detective Joseph Kremen on August 11, 2001, are fair and accurate representations of the crime scene, and that the photographs taken in May and June of 2012 by assigned ATF agent Detective David Plummer and labeled 25 to 32 are fair and accurate representations of the location of the streets, houses, trees, bushes, and signposts on the 3800 block of North 17th Street in Philadelphia on August 10th and 11th of 2011. Those are all of the stipulations that the parties have to offer.
Okay, all right, so ladies and gentlemen, you'll consider those along with all the other evidence that's been presented. All right, anything further from the government?
Only to be sure that we have moved to admit our exhibits, so that would be 1, 2, 3, 7, 10, 11, 12 and 13, 15, 43, and 45.
Well, what about the photographs?
They were stipulated, Your
They
Honor.
were both stipulated
They were-
to,
okay,
and
so
also
they're all right.
Mr. Zork
Right.
admitted them.
Yeah.
Okay, all right, so the government rests at this time?
Yes, we do, Your Honor.
All right, ladies and gentlemen, so the government has finished its testimony in this case. Now, before I decide, and I've got to consider certain things, legal issues from the lawyers. So I'm going to, at some point shortly, we're going to have a luncheon break, but I'm going to excuse you for just a recess for a few minutes while I discuss things with the lawyers, and then I'll have you come back in and we'll see what you are. Okay, so we will not, so we'll just take a 10-minute recess at this time. Thank you. go after the jury then, thank you. I asked Matt to come. Okay, we'll now hear the defendant's Rule 29 motion.
Yes, Your Honor. Just very briefly, I move for a judgment of acquittal. The government did not prove that Mr. Seals actually possessed or constructively possessed a weapon, let alone that he tossed the weapon. And based on the insufficiency of the evidence, I move for an acquittal. Thank you.
Okay, I'll take that matter under advisement pending the verdict of the jury.
Thank you, Your Honor.
Now, I excuse the jury. I would like to know whether you want to proceed or whether you want the luncheon recess to discuss this with your client, or if you've determined what your course will be.
Your Honor, discussed ad nauseum with Mr. Seals as to whether his right to testify. He does not want to testify. I have no other witnesses to present, so I'll be resting.
All right.
He understands his right to testify and that the decision is solely his.
All right. You've discussed that with him.
Yes, sir.
I
Numerous times.
don't see a need to have a colloquy on that. The Third Circuit has.
I wholeheartly agree with Your Honor on that.
So,
It's not necessary.
All right. And you don't have any other testimony, so you're prepared to rest?
Yes, sir.
All right. Well, now, then what I would do is I'd have the jury come back. You can say
Yes.
the government rests, and I'll say
appreciate
the
it.
testimony's over. Now, as I said, we have a judges meeting today, so the earliest I can reconvene is 1:45. But before I excuse you, I'd like to have the charge conference.
Yes, sir.
Right. We'll do that as soon as I excuse the jury. Then we'll have closing arguments. How long does the government want to argue? Ms. Maggot, how long do you want to argue?
12, 13 minutes, not very long.
All right.
Between 7 to 10 minutes, sir.
All right. Well, then we'll have arguments, and then I'll charge the jury this afternoon as well.
Would you like us back at 1:45 or 2 o'clock?
No, I'll tell the jury 1:45.
Okay.
Well, I'll tell them 2 o'clock, because I think, just to be sure, that'll give me more time to finalize the charge. Okay, bring the jury back in.
Thank you, Your Honor.
Thank you.
Okay, everyone be seated, please. Okay, Mr. Adama?
Yes, Your Honor. At this time, the defense rests.
Okay, thank you very much. All right, ladies and gentlemen, we've completed all the testimony in the case, and we had to have that little interlude for me to just go over some legal issues with the lawyers, which I've done, and talk about the schedule. For various reasons, in
as I said, the testimony is concluded. So the next item are the closing arguments of counsel and then the charge of the court. Now, I've determined the closing arguments are probably going to take in total about a half an hour, and the charge will take about the same. But I need to give the lawyers time to prepare it, and I've got to finalize the charge. And we have a judges meeting. For all those reasons, we're not going to be able to reconvene until 2 o'clock. So it's longer than we usually take for lunch, but you'll be presented with this case approximately 3 o'clock at the beginning of deliberation. So it's very important now to still keep an open mind. The closing arguments are very important. Please do not discuss the case with each other or reach any conclusions. And have a nice lunch, and I'll see you. We'll resume at 2 p.m. Thank you very much. Okay, thank you. All right, please be seated. All right, the charge will be as follows. I'll have the standard charge on reasonable doubt and burden of proof, and I will then explain the elements of the charge. We made a convicted felon in possession of a firearm. I'll charge the jury that there's evidence of the defendant's conviction before Commonwealth of Pennsylvania Court of a crime punishable for a term exceeding 1 year, and tell the jury they may not consider that evidence for any other purpose. The second element would be possession, and I will give a standard charge on possession. Then I will also charge on interstate commerce pursuant to the stipulation. Then I will give the standard charge on weighing the evidence. I have a charge prepared on Reginald Gibson as follows. You've heard testimony about Reginald Gibson, but he has not testified. I advise you that he is not available at either side of this case as a witness. Therefore, I instruct you may not consider his failure to testify in this court as having any bearing on your deliberation. Is that acceptable, the government?
Yes, acceptable. Just noting again that it's Gibbons, not
Gibbons,
Gibson.
sorry.
Sure.
Gibbons, Gibbs.
ONS.
Sorry, thank you. Is that acceptable to the defendant?
Yes, Your Honor.
All right. Okay, then I will give the standard charge on circumstantial and direct evidence, the standard charge on the defendant not testifying, credibility, and I'll give a charge on expert testimony, and that with regard to investigative techniques, I will tell the jury that they may consider all the facts, including that testimony, in determining whether the government has proved the defendant guilty, but there's no requirement that the government use any specific investigative techniques to prove its case. Anything further from the government?
Right, only with regard to the stipulations.
All right, I'll add a standard charge on stipulation.
Yes, thank you.
Okay. Anything else? From
No,
you?
Judge, that covers it.
Okay.
Thank you.
See you at 2 o'clock. Thank you.
2 o'clock then.
Thank you, Your
Thank you,
Honor.
Your Honor.
I was going to buy a condo in the Essex, and I begged her. I was like,
Okay.
good afternoon, Your Honor.
All ready?
Yes,
We are?
Ring is ringing.
What?
Okay, everyone be seated, please. Okay, we're now ready for closing arguments, ladies and gentlemen. Because the government has the burden of proof, the government attorneys get an opening and a closing argument. The closing argument, the first argument is usually longer, and the second argument is shorter in the nature of a reply argument to the defense. Okay.
Thank you, Your Honor. On August 10th, 2011, just before midnight, on a residential street in Philadelphia, this defendant, a convicted felon, possessed the gun, a semi-automatic weapon. He held it, he fired it, he threw it. He tried to conceal that dangerous weapon in a bush, but he cannot conceal from you what he did that night. He possessed a dangerous weapon. Good afternoon, ladies and gentlemen. This has been a short trial, and my comments this afternoon will be relatively brief. But please do not let the shortness of the trial indicate the seriousness of the crime. Being a convicted felon in possession of a firearm is a serious matter. As the evidence in this case shows you, guns are dangerous in the hands of the wrong person, hands like those of this defendant. This is my opportunity to speak to you about the case, and I am going to address a number of things. First, I'm going to summarize the evidence. And as Your Honor has told you, and he will instruct you again, though, this is the government's view of the evidence, and always your own recollection controls. Second, I'm going to describe what the charge is in this crime and what it is that the government must prove. And again, Your Honor will also instruct you on that matter. And third, I am going to describe to you how the evidence presented to you proves the charge. And finally, I will respond briefly to the comments of the defense and arguments that they have raised in their cross-examination questions. I'll return to you with additional comments about the defense arguments in my rebuttal argument when I come back to speak with you again after Mr. Adamo has an opportunity to speak with you. So first, let's start with the evidence. I think that you will conclude that it shows that the defendant made poor choices on the night of August 10th, 2011. Choices that put people in danger. And that the police officers, Officer Terry and Officer McEwen, made good choices that night. Choices that kept people out of harm's way. What the evidence shows is that on that night, just before midnight, Officers Terry and McEwen were on patrol on North 17th Street in the North Philadelphia part of the city. They were in uniform and they were in a marked car. They saw a man, Bryan Seals, look at them and then loudly scream, north, up 17th Street. One time, and he yelled it that loud. He was yelling a warning to someone north on 17th Street. Seconds after the officers heard that warning, they saw a man on the porch of 3846th Street running from the porch into the house. At the very same time, or 1 or 2 seconds afterward, I think they said, right after the gunshots, they saw another man. This defendant, Bryan Seals, standing on the sidewalk in front of 3842 North 17th Street. So just 2 row houses away from the man on the porch. The evidence shows that just after the shooting, the man on the sidewalk, the defendant, responded to the warning he had heard by turning, looking at the approaching police officers, and then you saw the movement, throwing an object away from his body and into the bush. Bryan Seals saw the approaching officers, and he had no way to escape on 17th Street. There were no alleys nearby, so he had to get rid of that gun. Consider what Officers Terry and McEwen did in the moments, the seconds, the minutes after they heard the gunshot and saw something thrown into the bush. Officer Terry, seeing that the defendant was the only person on the street near where the shots were fired, he went and stopped the defendant and arrested him. Officer McEwen, knowing the great risk of leaving a firearm, if it was a firearm, in that bush, went and looked in the bush for the gun, and he found it there. He found the loaded firearm. And even after he found it, he continued searching, and there was nothing else in that bush. Officer McEwen told you and showed you how he made the gun safe and how he made that neighborhood safe by unloading the gun. He removed it from the scene. After arresting the defendant, getting the gun from the bush, the officers told you that they also saw fired casings. Again, further evidence, in addition to hearing the gunshots, that there had been a shooting. They saw that there were 2 fired casings and a bullet on the porch of 3844. So 3846 is where they see a man run in the house. 3844, the porch has 2 casings and a bullet. And 3842, next door, is where the defendant was, and there are 2 more casings right where he is standing. Detective Kremen told you he was the assigned detective. Now, he came several hours later, but the scene had been protected and preserved by other officers. He came and collected all of this evidence. So first, he collected the casings and the bullet on the porch, the casings on the sidewalk, and then he went into 3846 and they found a gun. That's the second gun, the .40 caliber Taurus gun. Officer Whiteman, who is a firearms expert, then tested all of those items that had been found at the scene. And he told you that he determined, as an expert, that the casings on the porch matched the gun in the house, and the casings on the sidewalk matched the gun in the bush. Those casings, you can see, are very tiny bits of evidence in size, but they are very big pieces of evidence in terms of showing who had that gun, and in terms of showing that the only person standing near the gun and near the casings was this defendant. Officers Terry and McEwen both told you that the only person that they saw near where the shots were fired, near where they found the casings, near where they found the gun in the bush, was this defendant. Based on these events, Bryan Seals was indicted on just 1 count, but it is a serious count. The possession of a firearm by a person who has already been convicted of a felony and who is not allowed to possess any weapon at any time. His Honor will describe to you exactly what are the elements of the crime, but I'm going to go through each one of them now, because the government must prove them beyond a reasonable doubt. So first, the government must prove, as the first element, that the defendant has a prior criminal conviction for a felony. The parties, by that I mean the government and the defense, have entered what we call the stipulation, and that's just a fancy word for an agreement. The parties have reached an agreement that the defendant does, in fact, have a prior criminal conviction for a felony. So that first element is met. Second, the government must prove that this gun and the ammunition for it traveled in interstate commerce. That means the gun and the ammunition ended up in Pennsylvania, but they had to come from somewhere else, another state or another country. That's interstate nexus. Here, too, the parties reached a stipulation, an agreement, that this gun and the ammunition for it came from outside of Pennsylvania. You heard that, in fact, the gun says on it, Spain and Virginia. So that second element, interstate nexus, is also met. Third, the government must prove that the gun is legally a gun, meaning that it is operable, meaning that it works. Here, too, the parties reached a stipulation, an agreement that the gun is operable, and you also heard from firearms examiner Whiteman that in fact he test-fired the gun and it is operable. So that third element now is also met. Finally, we get to the heart of this case. The government must prove that the defendant, Bryan Seals, possessed the gun that Officer McEwen found in the bush. And on this critical point, the parties do not agree. You heard evidence, though, that Bryan Seals did possess the gun found in the bush, the gun that he threw in the bush. To prove this element of possession, the government does not have to show you that the gun was seen in the defendant's hand. The government has presented circumstantial evidence that the gun was in the defendant's hand, but that he then threw it into the bush where it was found. His Honor will instruct you on circumstantial evidence, but the evidence in this case presents a strong circumstantial case of possession. Officers McEwen and Terry heard the warning from Bryan Seals, then they heard the gunshots, then they saw the defendant, they saw him throw an object into the bush, an object that had weight. They found the gun in the bush. They found the casings from that gun virtually at the feet of the defendant. Ladies and gentlemen, is there any doubt in your mind that the defendant, Bryan Seals, possessed the gun and that he tried to get rid of the gun before he could be found with it? In evaluating the evidence, I know that you will use your common sense. Use your common sense to ask yourself whether Officers Terry and McEwen were credible when they told you what they did see, what they did hear, what they did in response to this. If they wanted to make up a story, you know what could have been. We saw the gun in his hand. But in fact, they told you that they saw an object with weight thrown from his hand into the bush, and that was the only object found there. You are the judges of their credibility, but they told you what they saw, what they heard, and what they did. Let me just very briefly comment on some of the arguments raised by Mr. Adamo's cross-examination questions. The defense criticizes some of the choices that the police officers made that evening, but they were in a dangerous, potentially volatile situation. We submit that the evidence shows that it is the defendant who made poor choices that night, and that the police officers made good choices that night, choices that protected public safety. The officers chose to get that gun out of the bush and off the street, instead of trying to leave it there and taking the risk that someone could lunge for it. There was no reason to leave the gun there in the vain hope that if they did, it could later be brought in and fingerprints recovered. Officer Trenwith, who testified today, is the most senior crime scene investigator right now in the entire Philadelphia Police Department. He explained to you that in his career of 2 decades in the crime scene unit, he has tried to get fingerprints hundreds and hundreds of times, and only once has he gotten a usable fingerprint from a firearm. It happens on CSI. It doesn't happen like that in the real world. In the real world, when police officers see that there is a gun that could be loaded on a public street, they pick it up. Officer Trenwith also told you about the gunshot residue test mentioned by the defense. And he told you that they almost never do that test. And that's because the test is just too unreliable. And he also told you that he would not expect to smell gunpowder on a person who has fired a gun and is then several feet away. Ladies and gentlemen, possession of a firearm by a convicted felon is a serious crime. It is true that no one was actually shot on October 10th of 2011, and thank goodness for that. But look at the incredible danger that was created because the defendant had a gun that he should not have had. He stood on a public street in a residential neighborhood in
Objection,
Philadelphia.
Judge.
Just sustain the objection. Let's
Yeah.
limit yourself to the evidence. Thank you.
He stood on a public street with a gun in his hand that he should not have had. In just another moment or two, Mr. Adama will have his opportunity to speak to you on behalf of the defendant. And after all of the arguments, when you go to deliberate, I hope that you will ask yourself why it is that Bryan Seals was standing on a corner shouting a warning in the direction of the defendant. And why did the defendant, Bryan Seals, respond to police presence by throwing something into a bush? And why is it that after a thorough search of the bush, the only thing the police officers found in the bush was a gun, and a gun that looked like it had just been thrown there and that matched casings found at the feet of the defendant? Ladies and gentlemen, the evidence shows that the government has established beyond a reasonable doubt on the night of August 10th, 2011, that the defendant, Bryan Seals, possessed a deadly weapon while he was on a street in Philadelphia. I ask you to return a verdict of guilty. Thank you.
Mr. Adama?
Thank you, sir. Your Honor? Good. Counsel, ladies and gentlemen of the jury. One of the geniuses of the Anglo-American mind was to create a constitutional democracy. And in our form of government, we have separations of power. The most important aspect that's relevant to this case is that these fine attorneys work for you. You are their bosses. They're not your bosses. I'm going to make that part of my argument. I'll bring that to light. When the government presented their case against Mr. Seals, contained in Exhibits 25 to 32, you saw pictures of the scene, but they're broad daylight. This event happened at 11:45 in the evening. Take a look at Exhibit 20. Exhibit 20 shows you how it was, how it looked, how that area looked in the evening at 11:45. That's very important, because this case boils down to what the officers thought they saw. Now, and it's very important to look at the lighting conditions, look at how everything is situated. Testimony indicates that that is a residential area, that there was cars jam-packed on the side of the road where the alleged incident happened. The officers were coming up the road. It's very dark, it's very dim. I submit that they didn't see anything as far as the toss is concerned. You look at that picture, you can't see much in that picture. That's the view that they had, not the view that the government tried to portray in Exhibit 25 through 32, that was in broad daylight and it was easy to see. I suggest, ladies and gentlemen, they have the burden of proof. I suggest you take that into consideration as to how the government presented their case to you. Think about how they presented that case. This is the United States government. They have all the resources. Do they want to go out there and take pictures to show you a true and accurate portrayal of how things looked? I submit they did not. They intentionally, in Exhibit 25 to 32, showed you a misrepresentation of how things looked. Exhibit 20, that's the key. That shows you what these officers saw. Look at Exhibit 20. That's the key. They didn't see Mr. Seals throw anything. They saw Mr. Seals in an area. They saw two additional men as well in that area. They're just trying to go to the easiest person possible. And it's great. You had the officer, the police officer, the last one, the expert on firearms, said, nah, in my career of 36 years, only one time did I get fingerprints. Take a look at Detective Crimmins' testimony. Detective Crimmins specifically said, and I crossed him on it, he said, nah, it wasn't preserved. The gun wasn't preserved. All it would take is a plastic glove, a hanky, some paper to preserve the evidence so that you have the print. The reason why they never got a print? That's because they do sloppy police work. And they want to say, oh, don't hold us to the standard of CSI. That's because they're sloppy, and they're able to get away with it. They're able to get away with it. It's up to you. It's up to you to make them accountable. It's up to you to stand up, make them accountable, make them prove their case, rather than innuendos and speeches and nonsense. That's all you got. You got nonsense. Exhibit 20, that shows you, ladies and gentlemen, that shows you what it looked like. And if you look at that, you can't see anything. And the officers really didn't see anything. They thought they saw something, and it turned out there was something there. My client didn't do anything wrong. He was at the wrong place at the wrong time. I submit you take a look at this evidence. You look at this closely. You look at that exhibit. You're going to find out that this man is not guilty. This man is not guilty. He's guilty of being out on the street at 11:45 in August. That's it. That's the only thing he's guilty of. Anything other than that, he is not guilty of all of these charges. Thank you very much.
Ms. Megan, a short reply.
Just very briefly, ladies and gentlemen, regarding the lighting, you heard from the officers that there was, although this was shortly before midnight, that there was a fair bit of light there. They told you that there was enough light to see what they saw. You are the judge of their credibility, but please remember that they said they were driving towards the defendant, he was facing them, and they had their headlights on. They also said that there were streetlights on, city streetlights on there, and they said that there were also house lights on from some of the homes as well. They told you that there was enough light. With regard to the photographs, the government is doing nothing to mislead you. The photographs that were taken during daylight were presented to you so that the officers could show you the locations of where the houses are and where they found the casings. We did not purport to say that those were in fact the photographs taken at the time of the evidence. They were taken so that you could get a clearer picture of where 3846, 3844, and 3842 were. 3846 where the man ran in, 3844 where there were casings on the porch, 3842 casings on the sidewalk. So you could see just how close these were to each other. Somebody shot the gun. Somebody fired the gun that was in the bush because the casings were on the ground. And the only person that was on that street at the time was the defendant. Both officers told you that they saw no one else near the gun or anywhere near in that area. Finally, with regard to preserving the gun could not have been preserved with, I believe what was said was a plastic or something. That gun had just been fired, it was in the bush. You heard that Officer McEwen did the right thing by going it in and taking it out. It could not be left in the bush, he had to look for it in the bush and then take it out. Once you have taken the gun out, what needs to be done with it next is to make it safe. And you saw several officers, you saw Officer McEwen and Detective Kremen show you how a gun is made safe. It is touched all over. You've got to touch a lot of parts of that gun. At that point, that gun has not been preserved. You also heard from Officer Trenwick that even when guns are preserved, even when there's a gun at the scene and they can leave it there and a gun is preserved, he has gotten one print in his career of trying to get prints from hundreds of guns, so it would not have made a difference. Thank you.
Okay, ladies and gentlemen, that completes the closing arguments. So it's now time for me to give you the charge, which I said will take about a half an hour.
If any of you would like a break at this time before I charge, raise your hand. If not, I'll keep right on going. Okay. Now, you're welcome to take notes, but I'm going to provide you with a typewritten copy of 95% of what I'm about to say. So if you don't hear or if you don't understand anything or you want to check it, you'll have a typewritten copy. Now that you've heard the evidence and the arguments of the attorneys, it's my duty to instruct you as to the law applicable in this case. Upon my conclusion, you will retire to consider your verdict. and I'm going to give you a written copy of this charge. You have two duties as a jury. First is to decide the facts from the evidence that you have heard and have seen in court during this trial. That's your job and your job alone. I play no part in finding the facts. You should not take anything I may have said or done during the trial as indicating what I think of the evidence or what I think your verdict should be. Your second duty is to apply the law that I give you to the facts. My role now is to explain to you the legal principles that must guide you in your decisions. You must apply my instruction carefully. Each of them is important. You must apply all of them. You must not substitute or follow your own motions or notion or opinion about what the law is or ought to be. You must apply the law that I give to you, whether you agree with it or not. Whatever your verdict, it must be unanimous. All of you will have to agree on it, or there will be no verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up his or her own mind. This is a responsibility that each of you has, and you cannot avoid it. I will give you a verdict slip which will list the charge, and you will provide a check-off for either guilty or not guilty. If your verdict is guilty, it's my job to decide what punishment should be imposed. You should not guess about the punishment. It should not enter into your consideration or discussion at any time. Perform these duties fairly and impartially. Do not allow sympathy, prejudice, fear, or public opinion to influence you. You should also not be influenced by any person's race, color, religion, national ancestry, gender, profession, economic circumstances, or position in life or in the community. The defendant in this case, Bryan Seals, pleaded not guilty to the offense charged and is presumed to be innocent. He started the trial with a clean slate with no evidence against him. The presumption of innocence stays with him unless and until the government has presented evidence that overcomes that presumption by convincing you that Mr. Seals is guilty of the offense charged beyond a reasonable doubt. The presumption of innocence requires that you find Mr. Seals not guilty unless you're satisfied that the government has proved guilt beyond a reasonable doubt. The presumption of innocence means that Mr. Seals has no burden or obligation to present any evidence at all or to prove that he is not guilty. The burden or obligation of proof is on the government to prove that Mr. Seals is guilty, and this burden stays with the government throughout the trial. Some of you may have served as jurors in civil cases where you were told that it is only necessary for a plaintiff to prove that a fact is more likely true than not true. That is not the rule in a criminal case. In a criminal case, the government proof must be more powerful than that. It must be beyond a reasonable doubt. In order for you to find Mr. Seals guilty of the offense charge, the government must convince you that he is guilty beyond a reasonable doubt. That means the government must prove each and every element of the offense charge beyond a reasonable doubt. You may not find a defendant guilty based upon mere speculation, suspicion, or probability of guilt. It must be proved beyond a reasonable doubt. On the other hand, there are very few things in the world that we know with absolute certainty. And in criminal cases, the law does not require proof to a mathematical certainty or proof that overcomes every possible doubt. Possible doubt, or doubts based on conjecture, speculation, or hunch, are not reasonable doubts. A reasonable doubt is a fair doubt, based on reason, logic, common sense, or experience. It is a doubt that an ordinary reasonable person has, after carefully weighing all of the evidence, and is a doubt of the sort that would cause him or her to hesitate to act in matters of importance in his or her own life. It may arise from the evidence, the lack of evidence, or in the nature of the evidence. Although the government is required to prove Mr. Seals guilty beyond a reasonable doubt, the government is not required to present all possible evidence related to the case or to produce all possible witnesses who might have some knowledge about the facts of the case. In addition, as I have explained, Mr. Seals is not required to present any evidence or produce any witnesses. If, having now heard all the evidence, you're convinced that the government proved each and every element of the offense charged beyond a reasonable doubt, you should return a verdict of guilty for that offense. However, if you have a reasonable doubt about one or more of the elements of the offense charged, you must return a verdict of not guilty for that offense. The defendant has been charged in an indictment, which is just a formal way of specifying the exact crime the defendant is accused of committing. An indictment is simply a description of the charge against a defendant. It is an accusation only. An indictment is not evidence of anything, and you should not give any weight to the fact that Mr. Seals has been indicted in making your decision in this case. I will now charge you on the law as to the count in the indictment. There's only one count. In Philadelphia, in the Eastern District of Pennsylvania, Ryan Fields is charged with 1 count of possession of a firearm and ammunition by a convicted felon in violation of Title 18 United States Code, Section 922G1. For the purpose of the offense charged in the indictment, the term firearm means any weapon which will expel or is designed to or may readily be converted to expel a projectile by the action of an explosive. The term includes the frame or receiver of any such weapon. For the purposes of the offense charged in the indictment, the term ammunition means ammunition or cartridge cases, primers, bullets, or propellant powder designed for use in any firearm. For the purposes of the offenses charged in the indictment, the term firearm means any weapon which will expel or is designed or may readily be converted to expel a projectile. The indictment charges Ryan Seals with being a convicted felon in possession of a firearm and ammunition. To meet its burden of proof that Ryan Seals was a convicted felon in possession of a firearm and ammunition, as charged in the indictment, the government must prove beyond a reasonable doubt each of the following elements. 1, first, that Ryan Seals had been convicted of a felony, that is, a crime punishable by imprisonment for a term exceeding 1 year. Second, that after this conviction, Ryan Seals knowingly possessed the firearm and ammunition described in the indictment. And third, that Ryan Seals' possession was in or affecting interstate or foreign commerce. You have heard evidence that, by way of a stipulation, that Ryan Seals was convicted before this incident in the court of the Commonwealth of Pennsylvania of a crime punishable by imprisonment for a term exceeding 1 year. The prior conviction was brought to your attention only because it tends to establish one of the elements of the crime of possession of a firearm and ammunition by a convicted felon as set forth in the indictment. You may not consider the prior conviction in deciding whether Mr. Seals was in knowing possession of the firearm and ammunition that he's charged in this case with possessing, which is a disputed issue in this case. The fact that Mr. Seals was found guilty of another crime on another occasion does not mean that he has committed the crime charged in this indictment, and you may not use his guilt of the other crime as proof of the crime charged in this case, except for the one element of this crime which I have mentioned. You may find Mr. Seals guilty of this crime only if the government has proved beyond a reasonable doubt all of the elements of this crime. To establish the second element of the offense charged in this indictment, the government must prove beyond a reasonable doubt that Ryan Seals knowingly possessed the firearm and ammunition in question. To possess means to have something within a person's control. The government does not have to prove that Mr. Seals physically held the firearm, that is, had actual possession of it. As long as the firearm was within Mr. Seals' control, he possessed it. If you find that Mr. Seals either had actual possession of the firearm and ammunition, or had the power and intention to exercise control over it, even though it was not in Mr. Seals' physical possession, that is, that Mr. Seals had the ability to take actual possession of the object when he wanted to do so, you may find that the government has proven possession. Possession may be momentary or fleeting. Proof of ownership of the firearm and ammunition is not required. The government must prove that Mr. Seals knowingly possessed the firearm and ammunition described in the indictment. This means that Mr. Seals possessed the firearm and ammunition purposely and voluntarily, and not by accident or mistake. It also means that Mr. Seals knew the objects were a firearm and an ammunition. Now let me just say one more word about possession. And sometimes I use, as an example, a pencil. Now I'm holding, and this is not in the written instructions, but just, now I'm holding this pencil in my hand right now that you can all see. So I think any person would consider that I am in possession of this pencil. Now if I put the pencil down there next to the witness box where nobody is, then there's a question of whether I am in possession of the pencil or not. Now, some people may say I am in possession because I could just reach out and grab it. On the other hand, if it was down there in front of the witness box, then it may be too far away, and some person might say it's not then in my possession. Now, if I had it right here in front of the bench, say equidistant between myself and the court reporter, then somebody might say it's in joint possession, because either one of us could reach out and grab it in that sense. Now, in this case, the little hypothetical that I gave you, I don't think really fits any of the evidence. So my purpose in charging you, though, is not to review the facts, because you're the judges of the facts. It has not been a lengthy case. You've heard all the facts this morning, and you have to decide from those facts whether the government has proved beyond a reasonable doubt that the defendant was in possession of the gun as I've described it. So that's your job, to take the facts that you find to be credible and to consider the government's burden of proof, and then determine whether the government has proved beyond a reasonable doubt that the defendant was in possession of the gun and the ammunition. The third and final element of the offense charged in the indictment is that the government must prove beyond a reasonable doubt that the firearm and ammunition specified in the indictment were in or affecting interstate or foreign commerce. This means that the government must prove that at some time before Ryan Seal's possession, the firearm had traveled in interstate or foreign commerce. It is sufficient for the government to satisfy this element by proving that at any time prior to the date charged in the indictment, the firearm and ammunition crossed the state line or the United States border. The government does not need to prove that a defendant himself carried it across the state line or the U.S. border, or to prove who carried it across or how it was transported. It is also not necessary for the government to prove that the defendant knew that the firearm and ammunition had traveled in interstate commerce. In this regard, there has been evidence that the firearms in question were manufactured in a different state or country than the state where Ryan Seals is charged with possessing it. So you recall you heard a stipulation about that. You're permitted to infer from this fact that the firearm traveled in interstate commerce. However, you are not required to do so. Now that I have laid out the elements of the offense charged in the indictment and defined those elements, I'm going to give you some general instructions about how you should consider the evidence presented in this case. You must make your decision in this case based only on the evidence that you saw and heard in the courtroom. Do not let rumors, suspicions, or anything else that you may have seen or heard outside of the court influence your decision in any way. The evidence from which you are to find the facts consists of the following: the testimony of the witnesses, documents and other things received as exhibits, any fact or testimony that was stipulated, that is formally agreed to by the parties, and any fact or evidence of which the court took judicial notice. I don't think there were any of those. The following are not evidence: the indictment, statements and arguments of the lawyers for the parties in the case, questions by the lawyers and questions I may have asked, objections by lawyers, including objections in which the lawyers stated facts, any testimony I struck or told you to disregard, and anything else you may have seen or heard about this case outside the courtroom. You should use your common sense in weighing the evidence. Consider it in light of your everyday experience with people and events, and give it whatever weight you believe it deserves. If your experience and common sense tells you that certain evidence reasonably leads you to a conclusion, you may reach that conclusion. The rules of evidence control what can be received in evidence. During the trial, the lawyers objected when they thought that evidence was offered that was not permitted by the rules of evidence. These objections simply meant that the lawyers were asking you to decide whether the evidence would be allowed under the rules. You should not be influenced by the fact that an objection was made. You should also not be influenced by my rulings on objections or any sidebar conferences you may have overheard. When I overruled an objection, the question was answered or the exhibit was received as evidence, and you should treat that testimony or exhibit like any other. When I allowed evidence, testimony, or exhibits for a limited purpose only, I instructed you to consider that evidence only for that limited purpose, and you must do that. When I sustained an objection, the question was not answered or the exhibit was not received as evidence. You must disregard the question or the exhibit entirely. Do not think about or guess what the witness might have said in answer to the question. Do not think about or guess what the exhibit might have shown. Sometimes the witness may have already answered before a lawyer objected or before I ruled on the objection. If that happened and I sustained the objection, you must disregard the answer that was given. Also, if I ordered some testimony or other evidence to be stricken or removed from the record, you must disregard that evidence. When you're deciding this case, you must not consider or be influenced in any way by the testimony or other evidence that I told you to disregard. Although the lawyers may have called your attention to certain facts or factual conclusions that they thought were important, what the lawyer said is not evidence. It is not binding on you. It is your own recollection and interpretation of the evidence that controls your decision in this case. Also, do not assume from anything I may have done or said during the trial that I have any opinion about any of the issues in this case or about what your verdict should be. Now, there are two types of evidence which are generally presented during a trial. One is what we call direct evidence. Direct evidence is the testimony of a witness who asserts or claims to have actual knowledge of a fact, such as an eyewitness. An example of direct evidence occurs when a witness testifies about something the witness knows from his or her own senses, something the witness has seen, touched, heard, or smelled. The other type of evidence is called circumstantial evidence. Circumstantial evidence is proof of a chain of events or circumstances indicating the existence of a fact. It is evidence that proves one or more facts from which you could reasonably find or infer the existence of some other fact or facts. A reasonable inference is simply a deduction or conclusion that reason, experience, and common sense lead you to make from the evidence. A reasonable inference is not a suspicion or a guess. It's a reasoned, logical decision to find that a disputed fact exists on the basis of another fact. For example, let's suppose you've been in this courtroom for 4 hours and you've not been able to look outside. A man comes into this courtroom wearing a wet raincoat and carrying a dripping umbrella. You may infer from those circumstances that it is raining outside. That is what we call circumstantial evidence as opposed to direct evidence. You've been inside the courtroom, so you physically can't see whether it's raining or not. Direct evidence would be the testimony of a man in a wet raincoat that it was raining outside. The law makes absolutely no distinction between the weight or value to be given to either direct or circumstantial evidence. Nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. The law simply requires that before convicting any defendant, the jury must be satisfied of the defendant's guilt beyond a reasonable doubt from all of the evidence, direct and circumstantial. Now, I think I should just say, ladies and gentlemen of the jury, and I think it's obvious that in this case there is no direct evidence that anyone saw the defendant, Bryan Seals, in possession of a gun. So this is a case in which you have to consider the circumstantial evidence and determine whether that is sufficient for the government to have met its burden of proving the defendant guilty beyond a reasonable doubt. You've heard testimony about Reginald Gibbons, but he has not testified. I advise you that he is not available to either side of this case as a witness. Therefore, I instruct you that you may not consider his failure to testify in this court as having any bearing on your deliberations. The government and the defendant have agreed that certain facts are true. That's where we have the stipulations. You should therefore treat these facts as having been proved. You're not required to do so, however, since you are the sole judges of the facts. The defendant, or Mr. Seals, did not testify and did not present evidence in this case. A defendant has an absolute constitutional right not to testify or present any evidence. The burden of proof remains with the prosecution throughout the entire trial. It never shifts to the defendant. The defendant is never required to prove that he is innocent. You must not attach any significance to the fact that Mr. Seals did not testify. You must not draw any adverse inference against him because he did not take the witness stand. Do not consider for any reason at all the fact that Mr. Seals did not testify. Do not discuss this fact during your deliberations or let it influence your decision in any way. All right, I now want to discuss the credibility of witnesses. In deciding what the facts are, you must decide what testimony you believe and what testimony you do not believe. You are the sole judges of the credibility of the witnesses. Credibility refers to whether a witness is worthy of belief. Was the witness truthful? Was the witness's testimony accurate? You may believe everything a witness says, only part of it, or none of it. You may decide whether to believe a witness based on his or her behavior and manner of testifying, the explanations the witness gave, and all the other evidence in the case, just as you would in any important matter where you're trying to decide if a person is truthful, straightforward, and accurate in his or her recollection. In deciding the question of credibility, remember to use your common sense, your good judgment, and your experience. In deciding what to believe, you may consider a number of factors. The opportunity and ability of the witness to see, hear, or know the things about which the witness testified, the quality of the witness's knowledge, understanding, and memory, the witness's appearance, behavior, and manner while testifying, whether the witness has an interest in the outcome of the case, or any motive, bias, or prejudice, any relation the witness may have had with a party in the case, and any effect the verdict may have on the witness, and whether the witness said or wrote anything before the trial that was different from the witness's testimony in court, whether the witness's testimony was consistent or inconsistent with other evidence that you believe, and any other factors that bear on whether the witness should be believed. Inconsistencies or discrepancies in a witness's testimony, or between the testimony of different witnesses, may or may not cause you to disbelieve a witness's testimony. And two or more persons witnessing an event may simply see or hear it differently. Mistaken recollection, like failure to recall, is a common human experience. In weighing the effect of an inconsistency, you should also consider whether it was about a matter of importance or an insignificant detail. You should also consider whether the inconsistency was innocent or intentional. You're not required to accept testimony even if the testimony was not contradicted and the witness was not impeached. You may decide that the witness is not worthy of belief because of the witness's bearing and demeanor, or because of the inherent improbability of the testimony, or for other reasons that are sufficient for you. After you make your judgment about the believability of a witness, you can then attach to that witness's testimony the importance or weight that you think it deserves. If you decide that a witness testified intentionally and falsely on a significant point, then you may, for that reason alone, if you wish, apply the old Latin rule, falsus in uno, falsus in omnibus, which means false in one, false in all. And you can disregard everything that the witness has said to you. However, you're not required to apply this rule. If you find the witness was truthful in one regard and intentionally untruthful in another, you may choose to disregard only that portion you find untruthful and accept the rest of the witness's testimony. The weight of the evidence to prove a fact does not necessarily depend on the number of witnesses who testified or the quantity of evidence that was presented. What is more important than numbers or quantity is how believable the witness is and how much weight you think their testimony deserves. You've heard the testimony of law enforcement officers or other witnesses who are or are employee of the government. The fact that a witness is a law enforcement official or otherwise employed by the government does not mean that his or her testimony necessarily deserves more or less consideration or greater or lesser weight than that of any other witness. At the same time, it is quite legitimate for defense counsel to try to attack the believability of a government witness on the ground that his testimony may be colored by a personal or professional interest in the outcome of a case. You must decide after reviewing all the evidence whether you believe the testimony of a law enforcement officer or other government employee and how much weight, if any, it deserves. The rules of evidence ordinarily do not permit witnesses to state their opinions about important questions in a trial, but there are exceptions to this rule. In this case, you heard testimony from witnesses who, because of knowledge, skill, experience, training, or education in a certain field, were permitted to offer opinions in that field and the reasons for these opinions. The opinions these witnesses state should receive whatever weight you think appropriate, given all the other evidence in the case. In weighing this opinion testimony, you may consider the witness's qualifications, the reasons for the witness's opinion, and the reliability of the information supporting the witness's opinion, as well as the other factors discussed in these instructions for weighing the testimony of witnesses. You may disregard the opinions entirely if you decide that those witnesses' opinions are not based on sufficient knowledge, skill, experience, training, or education. You may also disregard the opinions if you conclude that the reasons given in support of the opinions are not sound, if you conclude the opinions are not supported by the facts shown by the evidence, or if you think that the opinions are outweighed by other evidence. During the trial, you have heard testimony of witnesses and argument by counsel that the government did not utilize specific investigative techniques. You may consider these facts in deciding whether the government has met its burden of proof, because as I told you, you should look to all of the evidence or lack of evidence in deciding whether the defendant is guilty. However, there is no legal requirement that the government use any of these specific investigative techniques to prove this case. Law enforcement techniques are not your concern. Your concern, as I have said, is to determine whether or not, based on the evidence or lack of evidence, Ryan Seal's guilt has been proved beyond a reasonable doubt. Under your oath as jurors, you're not to be swayed by sympathy or bias. You're to be guided solely by the evidence in the case, and the crucial, difficult, and court question you must ask yourselves as you sift through the evidence is whether the government has presented sufficient evidence to prove Ryan Seal's guilty beyond a reasonable doubt. Intent and motive are different concepts and should never be confused. Motive is what prompts a person to act or fail to act. Intent refers only to the state of mind with which the act is done or omitted. Personal advancement and financial gain, for example, are two well-recognized motives for much of human conduct. These praiseworthy motives, however, may prompt one person to voluntary acts of good while prompting another person to voluntary acts of crime. Good motive alone is never a defense when the act done or omitted is a crime. The motive of the defendant, therefore, is immaterial except insofar as evidence of motive may aid in the determination of state of mind or the intent of the defendant. I'm just about to conclude my instructions regarding the law and the evidence and the offenses charged. I just want to explain a few things about your deliberations in your jury room. When you go to the jury room to begin considering the evidence in the case, I suggest that you first select one of the members of the jury to act as the foreperson. This person will speak for the jury here in court. He or she will also preside over your discussions. However, the views and vote of the foreperson are entitled to no greater weight than that of any other juror. As I mentioned several times, the decision you reach must be unanimous. You must all agree to the verdict. To find Ryan Seals guilty of an offense, every one of you must agree that the government has overcome the presumption of innocence with evidence that proves each element of the offense beyond a reasonable doubt. To find Mr. Seals not guilty, every one of you must agree that the government has failed to convince you beyond a reasonable doubt. If you decide that the government has proved Mr. Seals guilty, then it's my responsibility to decide what the appropriate punishment should be, and you should never consider the possible punishment in reaching your verdict. As I had said before, your verdict must be based only on the evidence received in this case and the law I have given to you. You should not take anything I may have said or done during the trial as indicating what I think of the evidence, what I think your verdict should be. That is your exclusive responsibility. It is your duty as jurors to talk with one another and deliberate in the jury room. You should try to reach an agreement if you can without doing violence to your individual judgment. Each of you must decide the case for yourself, but only after consideration of the evidence with the other members of the jury. While this is going on, do not hesitate to re-examine your own opinions and change your mind if you're convinced that you were wrong. But do not give up your honest beliefs solely because the others think differently or merely to get the case over with. In the end, your vote must be exactly that, your own vote. It is important for you to reach a unanimous agreement, but only if you can do so honestly and in good conscience. Listen carefully to what the other jurors have to say, and then decide for yourself if the government has proved the defendant guilty beyond a reasonable doubt. No one will be allowed to hear your discussions in the jury room, and no record will be made of what you say. You should all feel free to speak your minds. If you elected to take notes during the trial, your notes should be used only as memory aids. Do not give your notes greater weight than your independent recollection of the evidence. You should rely upon your own independent recollection of the evidence or lack of evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any more weight than the memory or impression of each juror. Once you start deliberating, do not talk about the case to the court officials or me or anyone else except each other. If you have any questions or messages, your foreperson should write them down on a piece of paper, sign them, and then give them to the court official who will give them to me. I will first talk to the lawyers about what you have asked, and I will respond as soon as I can. In the meantime, continue with your deliberations on some other subject. One more thing about messages. Do not ever write down or tell anyone how you or anyone else voted. That should stay secret until you have finished your deliberations. If you have occasion to communicate with the court while you're deliberating, do not disclose the number of jurors who have voted to convict or acquit on any offense. Now, a verdict form has been prepared. It's very simple. It just says on count one of the indictment, charging possession of a firearm and ammunition by a person previously convicted of a crime punishable by imprisonment for a term exceeding 1 year. We, the jury, unanimously find the defendant Bryan Seals, and there's a check off for either guilty or not guilty, and the fourth person will sign it. When you've okay, counsel want to see me at sidebar, Ms. Megan? You want to come to side? Anything you want to say at sidebar?
No,
No, Judge.
no,
All
we're
right.
fine.
Okay, all right, we'll now swear the court officer.
Do you swear that you will keep this jury in the quiet and peace for your deliberations, that you will allow no one to speak to them, who will speak to them themselves, that you usually before them, unless it be
All right, thank you. Now, the alternates, I want to thank you for your prompt attention. The practice in this courthouse is that when the jury retires, the alternates may not go to deliberate, but the alternates are not excused either. Ms. Lutz will give you a separate room where you can sit quietly or read or chat, whatever, but you will not be excused until the jury's reached a verdict. The reason for that is that I hope this doesn't happen, but it has happened on occasion. If any of the original 12 jurors becomes indisposed for any reason, gets sick or has to go home or something like that, the law allows me to substitute one of you for one of the original jurors, even though deliberations have started. So for that reason, you'll not excuse, but you will not deliberate either. So I'm going to ask the jurors to retire now. And the evidence will come out shortly, and here's the verdict form. Ms. Lutz will take out the copy of the charge. Now, one other thing, it's now 3 o'clock. As I said this morning, we generally don't keep jurors past 4:30. If you have a unanimous verdict by then, we'll take the verdict in open court. If you don't, I will then excuse you until tomorrow morning at 9 o'clock. In that event, you don't have to come back into the court. Ms. Lutz will just, actually, if you don't think you're going to reach a verdict anytime after 4 o'clock, and you want to come back tomorrow morning, that's okay. But If you think you can reach a verdict by 4:30, then I'd like you to stay till 4:30. If you do elect to go home, it's very important that you not discuss the case or anything that happened in the case while at home with anyone there. You must not, you can only deliberate when all 12 of you are together. So in that event, you would go home and stay silent about the case, come back tomorrow morning at 9 o'clock, but you may not start deliberating until all 12 of you are present in the jury room. And thank you very much. You may now retire to begin your deliberations. While you'll get the evidence, have you reviewed the evidence that's been presented? I didn't, I forgot to tell the bid, but I don't like to send firearms after, but all the other evidence. Yeah.
Right, okay.
Okay, so you'll let me know if you have any.
Right.
Okay, are you going to stick around?
Oh, in the courtroom.
Okay.
Yeah.
All right.
If I take a step outside, it'd be to get a cup of coffee and I'll tell your staff.
Not a problem.
Okay.
Thank you.
Right.
You'll pull them out of the books then.
All right, court's in recess pending.
Okay.
Well, should we, do we send you? Right.
Okay, I understand you have a verdict, counsel here, the defendant here, Superintendent. Okay, everyone be seated except the foreperson. Remain standing, please. Okay, has the jury reached a verdict?
Yes, I have.
Is the jury unanimous?
Yes, I
All right, Ms. Lutz will read the verdict sheet.
As to count one of the indictment charging possession of a firearm and ammunition by a person previously convicted of a crime, punishable by imprisonment for a term exceeding 1 year, do you find the defendant, Bryan Seals, guilty or not guilty? Guilty.
Please poll the jury.
Juror number 1, do you agree with the verdict as it has been recorded? Juror number 2, do you agree with the verdict as it has been recorded? Yes. Juror number 3, do you agree with the verdict as it has been recorded? Yes. Juror number 4, do you agree with the verdict as it has been recorded? Yes. Juror number 5, do you agree with the verdict as it has been recorded? Yes. Juror number 6, do you agree with the verdict as it has been recorded? Yes. Juror number 7, do you agree with the verdict as it has been recorded? Yes. Juror number 8, do you agree with the verdict as it has been recorded? Yes. Juror number 9, do you agree with the verdict as it has been recorded? Yes. Juror number 10, do you agree with the verdict as it has been recorded? Yes. Juror number 11, do you agree with the verdict as it has been recorded? Yes. Juror number 12, do you agree with the verdict as it has been recorded?
Yes.
Thank you. The verdict to be recorded. I want to thank the jury very much for your service as part of our jury program, and it's very important, as I said last week, when you're being chosen, to have individuals like yourself take time out, as inconvenient as it may be, to sit on a jury, and I appreciate your having done so. This was a short case, but an important one for both sides. We have some cases actually going on right now that last for weeks and weeks, so that hasn't been necessary in this case, but jury service is very important to make sure our courts can function. So the jury's excused with the thanks of the court. I want to thank the alternates as well, even though you didn't get to deliberate. All right, have a very nice day, ladies and gentlemen. You may find counsel want to talk to you after as you go out. That's up to you whether you're, now that you've had a verdict, you're welcome to talk to somebody if you want to, but you don't have to. All right, have a nice day. Thank you very much. Okay, we'll set a sentencing date. Do you have the date? All right, the January 10th at 4 p.m. All right, Mr. Seals, now that you have a verdict against you, and I don't know if you'll discuss with Mr. Adamo whether you want to file a motions or not, or if not, we'll proceed with the sentencing, and then you'll have a right to appeal. And I'll advise you of your rights to appeal at that time. All right, thank you very much.
Thank you, Your Honor.
Court's
Thank you,
in
Your
recess.
Honor.
Okay.
I'm going to give the government their notebook back.